Hello.
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 At 2 o'clock, if possible.
Face the music.
Well,
Face the music. What
uh,
wrong?
on Saturday, my lordship, I got the notice, my lordship, on Saturday. And, no confidence.
If it is illegal, it will be set aside. There cannot be stay, isn't it? It will be listed accordingly.
This is regarding silver market millet, which is earlier listed before vacation millet also.
Market, market, men's sport.
Bench for I and they said for pants. I don't know where.
Market is men's sport.
If you lost me, probably you lost me the bench 5.
Huh?
The body you lost me will take millet.
No,
It's the roaster.
roaster is men's sport. Settlement of market. Code number 10144. Settlement of market. Men's sport.
Here is writ petition relating to settlement by state government. Writ petition relating to settlement of by state government. Your lordship.
Is your case is panchayat?
No, this millet market.
Market by panchayat.
Near town millet. Town board.
Huh?
Town board, not market.
Town market also.
Oh, your lordship.
Have you mentioned before the bench
Millet.
4
Yes, I went there.
today?
Yes, good. Just. Oh, sorry, very called again. Sorry, Millet. Then he refused to throw Millet. I am your lordship.
This is bench 5 now.
I also know Millet. That is I went there.
Lordship, I beg to mention for listing a motion for Friday, Lordship. Cooperative society matter, Lordship. Obliged.
May I please, with the consent of the other side, I beg to mention item number 39 of today's list, my lord. In this case, my lord, engaged counsel are from Mumbai, my lord. There are some personal difficulties, they could not appear before this honorable court today, my lord. Kindly pass over the matter for today, my lord.
For the day.
For the day, my lord.
Okay. Mr. S. Hazarika.
My lord.
On the Mr. S. Hazarika, Learned Counsel for the petitioner has submitted that he is being led by counsel, outstation counsel, as the state outstation counsel is has some personal difficulty. Today he has paid for adjournment of the case for the day.
My lord.
You have informed the other side.
Yes, my lord. Other side, it's present, my lord.
MS M. Deka. You are standing counsel GST. You are standing counsel GST.
My lord, her senior is standing out. It is represented by SCK also, my lord.
Okay, representing Mr. S.C. Kyle, standing counsel GST, has no objection to the state prayer in view of the above prayer. The prayer made by Mr. Hazarika is allowed. The case is accordingly adjourned for the day.
Can it be on first week of December if possible, my lord, convenient?
Release the case. As prayed for, release the case on a date in the first week, on a date to be fixed by the registry in the first week of December.
Well, there is an interim order. my lord.
2023. The interim order after shall. No, the interim order 39.
I'm highly obliged, my lord.
1 minute, 1 minute.
Okay.
I have not seen it.
Well.
It is until further order, not required to extend
In the last occasion, it was made.
until further order.
Obliged, my lord.
You want to modify it?
No,
Then
my
we will
lord.
continue only on day-to-day basis.
No, my lord, in the last order, it was, earlier it was still the next returnable date, then it was,
On the previous date of listing, it has been extended until further order. If you want to make it
no, my lord.
modification, we can modify.
No.
Okay.
Obliged, my lord.
May I please, Lordship, regarding item number 40 and 41, my lord, the private respondent have served us the copy of the affidavit today, my lord. So we need some instruction, my lord. Any day on next week, my lord. The
Okay.
private respondent is present, my lord.
Mr. P.K. Bordoloi, you want to file reply?
We have to take instruction, my lord. Any day on next
Okay,
week, my lord.
Mr. P.K. Bordoloi, learned counsel for the petitioners in the two writ petitions, has submitted that he has received a copy of the counter affidavit filed by the private respondent today, only today, and he needs a week's time to obtain further instructions. He has thus paid for listing of the cases in the next week. Who is for private respondent?
Lordship, I am a
Mr.
HR.
HR
HR Das.
Das, learned counsel for the
Lordship,
private
date
respondent.
may be fixed, my lord. Otherwise, this case will become infructuous, my lord.
Was present, release the cases on next Wednesday.
Obliged.
Next case also, I am prepared for listing for withdrawal, my lord.
Or-
On Friday,
Friday.
my lord. May please, your lordship. Lordship, I am praying for listing contempt case, my lord, on Friday.
Friday. Wednesday,
My lord.
Monday.
Monday.
May I please, your lordship? I pray for adjournment, my lord. Item number 46, 47, and 48.
46, 47, and 48.
8.
Okay. You are for the petitioner.
Petitioner.
Okay, your name?
H.A. Talukdar.
On the prayer of Mr. H. Talukdar, learned counsel for the petitioners, the cases are passed over for the day.
Interim order condition, ma'am.
There is interim order.
Yes, ma'am.
Okay. The cases are adjourned till next Monday. You have informed the other side,
No,
huh?
not my lord.
Then you wait. If you are enjoying interim order, you are adjournment without informing the other side,
CGC,
you
no.
wait. You should have informed it.
I'll inform.
No, we wait then. This is not the practice. Yes.
List for motion item number 2.
Yes, lord.
Lordship, last occasion, my lord, instruction was served to my lord.
Come to page 8 of the writ petition.
My lord,
What is the prayer you are seeking here in this writ petition? Seeking arrest of respondent number 4 and to make proper and fair investigation.
because my lord, in the year 2022, my
No,
lord, FIR filed.
Come to the prayer.
Lordship,
There is twofold prayer.
Lord,
One is directing the respondent to arrest the accused persons, right?
Lordship,
And secondly, to make proper and fair investigation.
Lordship.
Now, my query to you is whether this kind of repetition is maintainable.
My lord, I can seek, my lord, fair investigation, my lord.
Fair investigation, right? That is why. That is precisely
Lordship,
the point.
Lordship, because they are sitting
If
over.
you are not satisfied with the kind of investigation by the investigating officer appointed for the purpose,
My lord,
what is the relief and which is the forum?
that I have availed, my lord, the.
What
immediate-
kind of,
Immediate authority, my lord, SP.
then thereafter,
Thereafter, my lord, I have not approached.
then Mr. Sharma,
FR was submitted, so Naraji petition he can file.
Then in that case, if it will be, if it Naraji,
Yes, yes.
As because in
if
this case.
FR has been submitted,
Yes.
Lordship,
then there is provision
Lordship,
under the CRPC
fine,
to file protest petition.
fine. My
If
lord,
you are not satisfied with the investigation,
my lord,
then you have to file
perhaps it is filed after,
156(3).
perhaps it is filed after filing of.
So if that information is provided to you,
My lord.
you will seek proper remedy. Let us,
Lordship. As
Let us-
because in the postmortem report, it was that.
no, tell me if final report has been submitted or not.
Yes, Lordship. Final report submitted.
Submitted.
Yes,
Then we can close it,
yes, yes.
Lordship, will-
reserving the liberty to the petitioner
Lordship.
to
That is
avail
the
appropriate remedy.
my lord,
Heard Mr.
M. Ali.
M. Ali, learned counsel for the petitioner, and Mr. H. Sharma, learned additional senior government advocate Assam, for all the respondents. Full stop. The case, in brief, projected in the state petition is that at about 2:30 AM or PM?
My lord, here it is written as 2:31.
AM or PM?
Not clear.
PM.
I think it should be,
On.
yes, PM, Lord.
That is why the translation
Lordship.
is not to be relied upon.
Lordship.
On 2/6/2022, comma, the petitioner's minor son was requested by another minor boy, aged about 9 years, comma, to accompany him to pick up mangoes from a place in the said village. Full stop. The petitioner has alleged that his son was taken to the house of one co-villager, and later on, comma, the body of the minor son, petitioner's minor son, was found hanging from a branch of a mango tree at the orchard of the co-villager. Full stop. In respect of the said incident, comma, petitioner stated to have lodged a first information report before the officer in charge, comma, Bogwan Police Station, against the suspected accused persons, number of suspected accused persons, comma, who are residents of Poop Panduba, comma, Police Station Bogwan, comma, District Gwalpara, full stop. As the officer in charge, comma, Bhagwan Police Station did not register any case against the accused person, comma, the petitioner approached the respond number 3, approached the Superintendent of Police Gwalpara, alleging non-registration of the FIR, full stop, on receipt of the FIR being forwarded by the Superintendent of Police Gwalpara, comma, the same came to be registered by the officer in charge, Bhagwan Police Station, as Bhagwan Police Station case number 46/2022 under sections 302/34, comma, Indian Penal Code. Full stop. Para. The petitioner has preferred the instant repetition with twofold prayers firstly, a direction to the respondents to arrest the accused persons in connection with Bhagwan Police Station case number 46/2022. And secondly, to make proper and fair investigation of Bhagwan Police Station case number 46/2022. Full stop. When the petition was moved on 30/8/2023, the learned additional senior government advocate was asked to obtain instructions in the matter. Full stop.
Lordship, I have received the instruction. Lordship may keep it as a part of the record.
Mr. Sharma, learned additional senior government advocate, who has received the instructions regarding Bhagwan Police Station case number 46/2022, has submitted that the case was investigated
From the previous page, the facts is in the previous page, and that is the action taken. There,
one.
post-mortem as well as the APA number is there. Lordship.
Case was registered on 7/8/2020. The case was investigated, the case, Bhagwan Police Station case number 46/2022 was investigated into, and after completion of the investigation, the case has been returned in final report, provide final report number 808/2023 dated 31/7/2023. Due to lack of sufficient evidence. Full stop. Para. Mr. Ali, learned counsel for the petitioner, on being apprised of the fact of submission of final report in connection with Bhagwan Police Station case number 46/2022, has submitted that the petitioner, in view of submission of final report, the petitioner would like to prefer appropriate remedy available to him under the provisions of the Code of Criminal Procedure 1973. And this writ petition can be closed at this stage. Full stop. In view of above submission made by Mr. Ali, learned counsel for the petitioner, this writ petition is closed, reserving the liberty to the petitioner to avail appropriate remedy in respect of the final report number so and so, dated 31/7/2023, as available to him under the Code of Criminal Procedure 1970.
That instruction may be kept as a part of
The instructions placed by Mr. Sharma, learned additional senior government advocate, Assam, is kept be kept as part of the
Lordship.
record.
Yes,
sir.
Item number 3.
May it please your lordship. My lord, initially, there was a controversy as to whether who would be the secretary of a cooperative society. There was a tussle between both, and the orders were against one another. Eventually, a writ petition was filed in this honorable court, and this honorable court was pleased to pass an order at page 25. All were represented. It was an inter partes order. Page 26. Second paragraph, first line. The central controversy. Lordship is there.
Page 27.
It starts at
26.
page 25.
Ah,
The order would start.
Central controversy.
The central controversy involved in this writ petition pertains to the question of legitimacy of either of the writ petitioner or the respondent number 6 to continue in the office of the secretary of the Dibru-Dangari River Part 1 Main Samabhai Samiti Limited. That was the issue therein. If my lord would skip 4 paragraphs today, towards the end. Lordship is there. Today, when the matter is called up, Mr. Banik, learned counsel for the writ petitioner submits that so as to end the uncertainty in the matter, the best recourse for this court would be to direct the respondent number 2, that is, the Registrar of Cooperative Societies, to decide on the question of legitimacy of the writ petitioner vis-a-vis the respondent number 6, to continue in the office of the Secretary of the Society. Since the AGM of the Society is scheduled on 29/9/2023, Mr. Banik submits that an attempt be made to decide on the said issue prior to holding of the AGM. Notices were issued for the AGM, dates were fixed. So at this time, this prayer was made. Mr. Rajkumar, learned standing counsel, Cooperation Department, as well as Mr. Hawk, learned counsel respondent from the 6, have also fairly agreed to such a recourse. In view of the above, without commenting on the merit of the claims of the counter claims of the parties, the writ petition stands disposed of with the consent of the parties by directing the respondent number 2 to decide on the question of legitimacy of the writ petitioner vis-a-vis the respondent number 6 to continue to function as the Secretary of the Board. The decision may be rendered either by the respondent number 2 himself or through any other competent officer authorized by him on that behalf. Whatever be the outcome of the exercise, the same may be communicated to the parties in writing. Since the AGM of the Society is fixed on 29/9/2023, the decision in the matter be taken as expeditiously as possible, preferably before holding the AGM of the Society. Notices may be served upon the parties notifying the date of the hearing, and the personal hearing may be given to them if desired before the final order is passed. With the above observation, the writ petition stands disposed of. My lord. So the AGM would be held. Prior to that, decide who would be the secretary, because notices were issued prior to that, much prior to that.
Preferably.
No, no,
Preferably.
it was decided also. I'm not on that. What I'm on is that 29 was the AGM, preferably decide prior to 29. Now the formalities for holding the AGM, the notices were issued much prior to that. Page 59.
Page?
59 is the order impugned. The genesis of the order, the basis on which it is, may I read them? In context to the subjects as aforesaid, you are hereby informed that the proceedings which were submitted on 29/9/2023, that's of the AGM, were examined, and it has been found that the notice issued for convening a meeting was signed by Sri Sanjay Das as the secretary, and presently Sri Sanjay Das is not the secretary. Therefore, approval to the proceedings dated 29/9/2023 cannot be granted. My lord, my humble prayer before your lordship is, when the notice was issued under the signature of the then secretary and the chairman, that was not in dispute. So the holding of the AGM was never interfered or restricted by the authorities on the count that who is the secretary to be disqualified. When on 29, 2 orders were issued. One, who is the secretary? We are not challenging that. The other person is the secretary, whoever is the secretary. But the proceedings of the AGM have been rejected on the count that the other man had signed it long back.
No, who was the petitioner there
My lord,
earlier?
in the writ petition,
No,
My
that
lord.
petition you have read.
writ petition
Your
was
name
to Sanjay
appears
Das. Sanjay Das was claiming on the basis of the secretary.
Sanjay Das.
He was claiming as to
Now, who is the petitioner here?
this writ petition, my lord. This is the chairman has come in.
Huh?
The board has come.
There you represented one secretary
Yes, yes, yes.
contesting.
That
Uh,
this was secretary's rights. The secretary has lost. We has not on that. No,
so
what we
meaning thereby, there is one cooperative society,
Lord.
registered cooperative society,
My
who is represented by the board of
board
directors.
of directors.
And there is another dispute between 2 persons who is holding the post of
That
secretary.
is ended also.
Huh?
That is ended.
That has
That
ended.
is ended. We are not challenging that also. That is ended. Someone should be the secretary, one is the secretary.
How it has ended?
Page 29, 32.
Huh?
Page 29,
29.
29. That is ended.
What is the sum and substance?
Sum and substance 32, Milo. Second last paragraph. Also on the basis, may I read that part?
Because thus.
He's a secretary now.
He is a
He's
secretary.
a secretary now. Let him be the secretary.
So Sanjay Das is not
No longer the
disputing.
secretary. He's not challenging that.
He is not
He's
challenging.
not challenging that.
When this order was passed?
29th of September.
20?
9th of September.
Okay.
The sole contention of the writ petition is that notices which were issued way prior, that cannot be the basis of rejection of the proceedings, my lord.
Whether other formalities are complied with, that is to be seen.
That is to be seen. But the fact that notice was issued by some person holding then, That cannot be a ground for rejection of the proceeding. That is our case.
There are procedures, statutory procedures required to be followed. Just because one person has issued, he is no longer a secretary, does not mean that it is not to be approved.
Lordship. Lordship,
If the board members were duly
yes,
put on notice
yes.
for a AGM and they have attended
Correct.
and quorum is there,
That quorum
They
was
have-
not there, Your Lordship.
that will see
That-
later on.
Yes, yes.
This is not.
But this could not
reflected-
be a ground,
Could not be a ground.
prima facie.
Lordship will kindly come to page 30, Your
No,
Lordship.
we'll issue notice at this stage.
Lordship.
We
Well,
cannot,
so
we
far as
cannot.
this is concerned, may I pray, my lord? Writ petition can be disposed of, directing them to take a call on merits of the matter, not on this technicality, my lord. That
Let
will
him
save the
obtain
procedure.
instruction, otherwise.
In the meantime, I'll pray for a stay of this matter, my lord. Because
What?
on this count, it has been rejected. They cannot improve on their order, my lord, by way of affidavit.
Let him obtain
Yes.
instructions.
Yes.
He has obtained the instruction, my lord.
Lord-
That's what he said.
I have Lordship obtained instruction, but I'll have submit an affidavit, Your Lordship, because what has happened, the instruction I have received, Your Lordship, that he is claiming that the quorum was there, Your Lordship, but the instruction I have received that there was no quorum was
Okay.
not there, Your
Reflected in the
Lordship.
order.
Only official respondents. Okay, only official response is good enough then. You file it within 10 days.
2 weeks time, Your Lordship, I'll file it.
We can take it up immediately.
Meantime, this order, what I am submitting, my lord, which subject to correction, my lord. What my colleague is submitting are grounds received under instructions. Now, the order does not reflect them. Perhaps in law, they cannot improve the ground of the order by way of affidavit.
Right, but at least the semblance of notice should be given to the respondents.
If I can make out a case for interim protection, my lord. If I have, because on the
Lordship, not
on
at
the,
this
on the
stage,
ground
Your
on
Lordship.
the ground on which it was rejected is no ground in law, my lord. They may have a better ground, but they cannot improve on law.
And Lordship will kindly come to page 30, Your Lordship, the hearing which was completed subsequent to this honorable court's order, Your Lordship.
Yes. We are
This
not having
honorable
the hearing
court has
also.
passed on 28th of October, Your Lordship, September. 22nd, the ARC has received communication from the RCS office, and then 28th and 29th, Your Lordship, the hearing was conducted. And irregularities were found, number of irregularities were found.
What irregularities?
Lordship will kindly come to page 30, Your Lordship.
Now, question is about
The AGM.
validity of the AGM on 29,
Yes, Your Lordship.
right?
Yes.
What is the prayer here?
We're challenging the 710.
His challenge is the AGM, Your Lordship.
70.
He is claiming that on
Rejection. The rejection of the AGM proceedings on the ground that the secretary was not the secretary then. is under challenge.
Basically, the proceedings of AGM are to be tested on the provisions of the Assam Cooperative Societies Act and the bylaws.
Yes,
My
Your
lord.
Lord.
Merely because one has, question is
Yes.
whether notices have been duly
Correct.
served or not.
Yes,
It is immaterial who has issued a notice,
yes, Your Lord.
right?
According
Just
to the-
because Sanjay Das had issued a notice at that point of time,
Right.
if all the board of directors or the quorum
Yes,
having received a notice have participated in the AGM,
yes.
then it is the proceedings of the AGM which will prevail,
Lordship, that is.
notwithstanding who had issued the notice.
Right, Your Lordship. So at para 7, he has stated, due to lack of quorum, the meeting officially convened by the chairman of the society, that is a petitioner, on 7/9/23 was adjourned and convened again on 14/9/23, on which date the quorum was achieved by co-opting members.
14/9.
14/9/23.
No, we are on to 29/9.
Yes, that is 14/9. He has the BOG meeting had happened, fixing the AGM on 29/9. That BOG meeting, Your Lordship, he had co-opted members, which it has been found that it was illegally done. The instruction that I have received, quorum was not achieved in BOD meeting on 14/9/2023, as per section 43, subsection 5 of the Cooperative Act, where the date of AGM was not notified as 29/9/23. So date was AGM was not notified. It is because so and so unlawfully removed 8 numbers BOD members and co-opted 2 number member in their place.
Then file your
So
affidavit.
Lordship, I'll
My
file
lord,
an
may I
affidavit,
say,
Your
this is
Lordship.
not the ground on which the order was rejected, the proceedings. He is taking a ground not permitted now. It cannot improve by way of an affidavit, my lord. This order has to go. What I am on is that they may have a better
No,
case.
question is also about stating the facts properly.
We have stated, narrated absolute correct. There is no suppression in this petition. No suppression, my lord. Nothing at all. What we are on is that the rejection of the proceedings is not on law. On account,
But
now
question is the steps
we have taken,
preceding
my lord.
the AGM.
my lordships.
Also, you are board of directors.
Absolutely
right?
correct. That was
Right.
not rejected on that count. Only when the writ petition was filed. they're
Since he
coming
has
up with this
already
fact.
received the instruction, let him file that.
But this is running counter to the stand in the order 710. 710 does not speak out all these things. 710 says since the secretary was a different man, so the proceedings are rejected. Now this has been abandoned. But this
And
calls
the
for
Honorable
intent
Court
protection.
said
my lord.
An attempt should be made.
On
That
on
was-
the face of it.
Right, we'll see the proceedings of the AGM leading to the AGM also.
But on the ground of this, my lord,
No, we have to see, only on the face of it, we cannot say. Let him respond. Within 17 days, you respond. We'll look into
they
it.
perhaps may not be permitted in law to take a contrary stand on it, my lord. They have spelled out their stand once.
Oh, let him take the stand.
Lordship will decide.
While you are preempting him, let him take the stand.
Waited before your lordship, my lord. He's taken the stand.
Right, let him take the stand. Since he has received the
Lordship will issue notice. and-
instructions,
I'll place.
A lordship may keep it for motion. He may file the affidavit. Because on the strength of that only, nothing more. This is they want to take a contrary stand.
okay, we'll put it on 20, we'll issue notice 2020,
2-0.
2 weeks.
Lordship.
Are Mr. S. Boni, learned counsel for the petitioner, and Mr. B. Raskua, learned standing counsel, cooperation department, for all the respondents. So, the petitioner cooperative society has assailed a communication, assailed the letter, a letter dated 7/10/2023, issued by the respondent number 3, whereby the respondent number 3 has declined to accord approval to the proceedings, AGM,
Lordship.
proceedings of the annual general meeting of the cooperative society, held on 29/9/2023, full stop. Mr. Bonik, learned counsel for the petitioner, has submitted that the ground on which the approval has been declined is untenable on the face of it. If the proceedings of the AGM of the society has been held in accordance with the provisions of the Assam Cooperative Societies Act 2007, the respondent number, it is not open for the respondent number 3 to decline approval on the ground mentioned there in the letter dated 7/10/2023. Full stop. Mr. Issue notice, Mr. Raskwa, learned counsel, standing counsel, cooperation department, has submitted that he has received the necessary instructions and a response can be filed within 2 weeks' time. Full stop. Issue notice returnable on 20/11/2023 as so and so, extra copies within 2 working days. Full stop. The respondent shall file its counter affidavit on or before the returnable date, so as to enable the court to adjudicate on the writ petition at the stage of admission.
Consideration of interim pay might come up. Not from the
Consideration, it is the consideration for interim pair is also kept open for consideration on the returnable date.
Obliged, lordship. Grateful.
Item number 4.
Yes,
This concerns the two tea stalls which
use these stalls, Wadarpur platform number 1,
Wadarpur
yes, for license
platform
agreement,
number 1.
commence its operation.
page 35 has been sketched, lordship.
Yes, MS Gayan.
Yes, my lord. I have already communicated the authority, my lord.
And then maintenance fix on 15, my lord. They are going to resolve the issue also, my lord. That maintenance fix, I'll take instruction on that day, my lord. I'll place in 15, my lord.
15, reasonable enough. Okay. MSB Chaudhary, Learned Counsel, heard MSP Chaudhary, Learned Counsel for the petitioners. And MS A. Gayon, Learned Central Government Council for all the respondents. MS Gayon, Learned CGC has submitted that instructions, full instructions in deference to the order dated 19/10/2023 have not yet been received. And she has paid, she has however submitted that the respondent authorities are in the process of resolving the issue pertaining to handing over of the possession of the stores and has paid for listing of the case on 15/11/2023 to enable her to obtain and place entire instructions in our matter. Full stop. The prayer made by MS Gayon, CGC, is accepted. Full stop. Place the case accordingly on 15/11/2023
Master.
in the motion column.
Item number 5.
May I please, your lordships. Lordship, this is a GST matter, Goods and Services Act. Lordship, my audit under GST provisions under section 65 of the Act was conducted for financial year 17/18 by the state GST department. They issued me certain observations, discrepancy memos, to which lordship I replied. And basis my reply, out of the 3 observations they issued, 1 was dropped, 2 certain of the demand was confirmed, which I paid. And I was issued a final closure report for financial year 17/18. Now, lordship, for the same financial year, I was issued on 28th of September a show cause notice on the point which was already dropped in the audit by the respondent number 2 for the same issue. The issue was regarding my reconciliation of my turnover for the purposes of GST and my tax paid. So that was already replied to during the audit proceedings. The audit was satisfied and they dropped. It is written in the order. This point is reconciled and the matter is closed. Now, lordship, 17/18 would have become time barred under the statute on 30th of September. So suddenly on 28th of September, a pop-up comes in my portal issuing a show cause notice on the same point which was closed by the audit.
Oh, is a show cause notice.
Lordship, the show cause notice is at page 46. Lordship, page 46 is the summary of the show cause. And the detailed show cause starts at page 48. My lordship is at page 46.
48.
Page 46, lordship, I just want to show one point. Page 46 is the summary of the show cause in DRC 01, lordship. And they say in A, brief facts of the case, non-filer of GSTR 9. Lordship, in page 46.
Yes.
Serial number A, brief facts of the case. They say non-filer of GSTR 9. GSTR 9 is my annual return, lordship. Now, lordship, I take you to page 48, which is the detailed show cause. Page 48, lordship, after the table, the first line, you have filed annual return in GSTR 9 for financial year 17/18. Summary of the show cause says the reason to issue this show cause is I have not filed GSTR 9. And the detailed show cause itself says on the first line that I have filed a GSTR 9. So, lordship, because it was becoming time barred on 30th September, just for the sake of issuance of show cause, they have issued me a show cause. Which itself, they are both the documents which is uploaded in the portal are self-disputing documents.
Let us read further.
Lordship, on examination of information furnished in this return under various heads, and also the information furnished in GSTR 1, 2A, 3B, e-way bill, and other records available in this office, it is found that you have not declared the correct tax liability while filing the annual return of GSTR 9. The summary of under declared tax is as below. So, Lordship, they have computed this from the figures as per my GSTR 9. Now, Lordship, I'll show this same figures was already closed 1 month back by the audit department, by the same wing of the state GST department.
Okay, let us see.
Lordship, that is right, Lordship. Kindly comes to, my Lordship, they kindly come to page 27. Lordship, this is page 27.
Yes.
Lordship, this is, Lordship, audit of the subject. Lordship, I am reading the subject. Audit observation in terms of Rule 101, Sub-Rule 4 of the Assam Goods and Service Tax Rules. Lordship, serial number 1. Short payment tax in GSTR 9. In GSTR 9 submitted by the auditee, the following discrepancies have been noticed. They have computed the same discrepancy, Lordship. They say central tax, tax payable, tax paid difference 16 lakh each. On the basis of GSTR 9. And in my Lordship has seen page number 48 also, that was also GSTR 9. Now, Lordship, second point, suppression of turnover as per records books of account. They say the auditee has submitted GSTR 9C and following irregularities have been observed while comparing taxable turnover available in GSTR 9 to that shown in 9C. And they have computed the discrepancy in the page 28. So, Lordship, both the points, the turnover and the tax liability. This was the audit memo issued to me, Lordships. I replied to this, Lordships. The reply starts at page number 29 onwards.
1 minute. What is this letter?
Lordship, this is the audit observation, page 27.
Brought to the notice authority if any further issue of interest, the same will form part of the audit notes. This letter is not in the nature of so cause notice.
Lordship, it is, Lordship, I take you to section 65, which says how does an audit operate, Lordship? The department takes documents.
Go to it, let me read the content.
Lordship.
You have read it many times. I have read it for the first time.
Lordship, I read it for your Lordships. I read again, Lordship, this page 27.
So it was preliminary and tentative audit observation.
Discrepancy memo, Lordship, as they say, as per the rules.
Okay.
To which we have to reply.
Then you reply.
I replied at page 29, Lordships.
29. Okay.
And it goes up to page 40.
40. Okay.
Lordship, then they issue me a report at page 41.
Audit report.
Page 41 is the report, which is the final audit report, Lordship, in ADP 02. May I place page 41 before your Lordships? Lordships. Subject audit report under 65(6) of the Assam Goods and Service Tax Act. Reference audit observation by letter number dated 29/5. Reply to audit observation by letter of event number dated 9/6. Your books of accounts and record for financial year 17-18, July 17 to March 18 has been examined, and this audit report is prepared based on the basis of the information available documents furnished by you, and the findings are as under. Number 1, short payment of tax. The auditee has discharged the tax liability amounting to rupees 2.41 CGST and 2.41 lakh SGST, both CGST, it should be SGST, during April 18, 2018 GSTR 3B. The auditee has disclosed the remaining balance in 18-19 with applicable interest. Hence, the objection is ignored. However, the auditee has made late payment of tax against the following invoices for which interest has to be paid. So they have computed my interest liability because my tax payment was delayed. The 16 lakh, which was the observation, they say you have paid it, but because you have delayed paid it, you pay interest to me. Next, Lordship, suppression of turnover as per books and records. The auditee has submitted reply to the audit observation in which the auditee has stated that the trade discount in GSTR 9 has been added to the turnover as per audited financial statement to ascertain revenue on which GST has been paid. The objection has been ignored. So they are satisfied with my reply and now workings given. The auditee has satisfactorily replied regarding unreconciled turnover. The objection has been ignored. And Lordship, finally, the summary of interest payable on the first point, they charge me interest. So that has been confirmed. And to this, Lordship, at next page 43, I have paid that amount. So Lordship, the proceeding concludes here. Section 65(6) of the statute, Lordship. Lordship, may I hand over the book?
Which book?
The CGST Act.
CGST.
CGST, Assam CGST. Both are same, Lordship.
The GST fund. Okay, before going into it, let us come back to page 48.
Lordships.
Yes, that observation non-filer may be a computer generated. Let us see the contents.
Lordship, the contents, Lordship.
Yes,
Page 48, Lordship. After the table I am reading, Lordships. You have filed annual return in GSTR 9 for financial year 17-18. On examination of information furnished in this return under various heads and also the information furnished in GSTR 1, 2A, 3B, e-way bill and other records available in this office, it is found that you have not declared your correct tax liability while filing the annual return of GSTR 9. The summary of under-declared tax is as below. SGST, CGST total.
Where is this figure already?
Lordship, this figure,
Page.
Lordship, this figure is at page number 27.
27.
Short payment of tax. 16 lakhs, 16 lakhs. And then the unreconciled turnover, 87 lakhs.
No, this figure
Lordship,
is 32,96,873. Short payment of GS.
Lordship, this
Tax.
32 lakh that they are computing here in this show cause, that amount was 16 lakh in the audit. Same period.
Page 27.
Page 27, Lordship.
Tax short paid, that column.
16 lakh 20.
These two figure comes to what?
These two figure come to 32.
32?
Under total, in the show cause, they are setting each had 32. Lordship, in page 48, you see the CGST total is 32 lakh, SGST total is 32 lakh. But for the same period, when the audit happened, the allegation was 16 lakh and 16 lakh difference, which was reconciled also. So how this figure has also...
This is a different figure.
But for the same period, different figure. Lordship.
Different.
Lordship.
Tell me that.
Lordship, different figure.
No, you first submitted that this is the same figure.
Lordship, I submitted for the same period, the
Some
same
period
issue,
may be same.
and the
Yes.
same issue, Lordship.
So then let us go on.
Lordship. Then, Lordship, the details of the above tax liability are as below. Number 1, under declaration of output tax, the tax on outward supplies under declared on reconciliation of data in GSTR 9. It is observed that the taxpayer has not correctly declared tax on his outward supplies on reconciliation of turnover in GSTR 9. Now, Lordship, they prepare a table. They say the tax on taxable supplies as declared in GSTR 9, reference of column number is given, and the amounts are given.
Right. That is what this figure is telling.
Telling, Lordship.
This figure is telling.
It is telling,
All the
Lordship.
other figures are additional.
Lordship. So the same department, my point is, Lordship, audit. I take you to a definition of audit which will clearly show, Lordship. Audit wing is that wing which has to scrutinize each and every record of the SSE, and then
issue a discrepancy note, which was issued, which your lordship has seen at page 27.
Now, here we are at the stage of issuance of show cause.
Lord-
Now, what is your requisition?
Lordship, my prayer is, lordship, I go on to the route of the jurisdiction of the officer issuing the show cause, because when section 65(6) says when an audit for a period is completed and an audit report is issued and the payment is made, the chapter closes there. If the payment is
65.
Lordship. My lordships are at Lordships, I read section 65, subsection 6. Lordship, may I read 65(6), Lordship, yes. On conclusion of audit, the proper official shall within 30 days inform the registered person records are audited about the findings, his rights and obligations, and the reasons for such finding. That was the audit memo, Lordship, at page 27, which your Lordship seen. Next, 65(7). Where the audit conducted under subsection 1 results in detection of tax not paid or short paid or unnecessarily refunded or input tax credit wrongly availed or utilized, the proper officer may initiate an action under 73 or 74. So, Lordship, in my case, the ADT 2 had shown that this point is closed, it is dropped. So, the issuance of show cause under 73, reference to section 65(7) does not occur at all, because the ADT 2, which was issued under 65(6), says this has been reconciled and the matter is ignored. And Lordship, very relevant would be the definition of audit, Lordship. Why I say, Lordship, once I take your Lordship to the definition of audit, first time in the statute, Lordship, erstwhile in the state tax also, there was no definition of this term audit. In GST, they have defined what is the scope of audit, Lordship, which is at page number 11 of my petition. I have extracted the definition.
What is the end portion of the show cause notice? Let us see.
Lordship, page 48, we are at page 48, Lordship. Then, Lordship, page 49 is a second allegation, excess claim of ITC, some amount of 84,000 is there. They have computed that table. I read, Lordship. The excess input tax credit claimed on account of non-reconciliation of information under section 16(2)(c), every registered person shall be entitled to take credit of ITC on supply of goods or services to him, subject to the condition that a tax charged in respect of such supply has been actually paid to the government, either in cash or through utilization of ITC, admissal in respect of such supply. It is observed that the taxpayer has not correctly availed input tax credit on his inward supplies on reconciliation of turnovers in GSTR 9 under declaration of ineligible ITC. Under section 17(5) of the Act, input tax credit shall not be available in respect of list of commodities and services mentioned therein, subject to some conditions. It is seen from GSTR 9 and other information that they have claimed ITC on these commodities, and therefore ITC claimed on these commodities or services is proposed to be recovered. Now, Lordship, very important pertinent here will be GSTR 9 cannot list these, because GSTR 9 only contains figures. The HSN, the details, these were all submitted during audit. All my input tax credit bills were verified by the audit department. Then, Lordship, they give this table, and then page 50 is the summary, the total tax due. Lordship, may kindly come to section 2, subsection 13 once. The definition of audit in the statute, Lordship. 2 subsection 13. May I please, Lordships? Audit means examination of records, returns, and other documents maintained or furnished by the registered person under this act or rules made thereunder, or under any other law for the time being enforced, to verify A, the correctness of turnover declared, the taxes paid, the refund claimed, and the input tax credit availed, and to assess his compliance with the provisions of the act or rules. Lordship, it covers 4 things in the gamut. The correctness of turnover declared, taxes paid, refund claim, and ITC availed. Audit, in my case, was completed. They issued me an ADT2 after the detailed process of audit for 3 months. I replied to that. They closed after the payments I made. Then, Lordship, for the same self period, without conducting any investigation, had it been a case of Lordship section 67 or a search seizure, I would not have come before your Lordships. The same officer, the same respondent number 2 who conducted the audit, who gave us a closure report, has now suddenly issued a show cause on the portal, just relying on certain figures.
Provisions of section 73 and
Lordship,
74.
Lordship, I'll pay some. Section 73 is the Lordship provision for.
Because these 2 sections come after section 66.
Lordship, 65(6), Lordship, 65(7). May I just read once more? 65(7).
Yes.
Where the audit conducted under subsection 1 results in detection of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized, proper officer may initiate action under 73. So when does 73 comes, Lordship? If under the audit, it is seen, I have short paid tax, I have claimed irregular refund, I have availed ineligible ITC, then I will be proceeded with a show cause notice if I don't pay up. In my case, audit report is at page number 41, Lordships. They have closed every point after reconciliation, page 41, Lordships. Audit report under 65(6) of the Act. The objection has been ignored. The payment has been made.
Yes, on this short point, Mr. Gogoi.
First of all, the document impugned in the present petition is a show cause notice, my lord. The document impugned in the present writ proceeding is a show cause notice, my lord, issued by the authority pursuant to the provisions of a particular act. Now here, my lord, this show cause was issued on 28/9/23. Whatever amendment they have made before this honorable court, they ought to have submitted a reply to that effect, my lord. It's not that.
Right, that is one course of action, because
Yes.
only thing is that section 65(6)
My lord.
and section 65(7).
Lordship.
Suppose if that page 41 is the audit report
My lord.
under section 65(6),
Lordship.
then there is only observation is that you pay this amount,
Yes,
failing which proceedings will be
my lord. I
initiated.
understand, my lord. Page 41.
Now thereafter they have complied,
Lordship.
they have deposited, what they have stated.
My lord.
Within 2 days, they have
Lordship.
paid.
Lordship.
Then, according to the petitioner, that there is no jurisdiction to issue a show cause notice.
Lordship.
Because if the matter is regarding jurisdiction, then
Yes.
yes, that option is always open.
Lordship.
But question is whether there is jurisdiction.
Whether we can issue a show cause notice thereafter,
After.
after the acceptance of the matter audit report.
Because we are confining to section 65(6) and 65(7).
Lordship.
If whether this can be interpreted,
In that regard, my lord, I will have to seek the instruction as to-
results in
because,
detail.
my lord, the authority is not the same authority, my lord. Where is-
Now,
that's the
Mr.
problem.
Counsel,
Lordships,
this has resulted into audit report,
Lordships.
right? And this has resulted into also an observation that detection of not paid or late payment, whatever, there is an observation.
Lordship,
Then if one way of interpretation of subsection 7,
Lordships,
that proper officer may initiate action.
Lordship,
Just because the observation made,
Lordships,
page 42, last line,
Lordships,
failing which proceedings as deemed fit may be initiated.
Lordships. Lordship, that is what the
That
provision says.
audit report has not said that audit has been closed, your chapter is closed.
Lordship, I want the 2 points, the turnover and the tax paid. Point number 1 and point number 2 of the audit report. They say it has been satisfactorily reconciled and ignored, closed. So when the audit has already closed that point, and your Lordship has seen the definition of audit under 213, Lordship, kindly see page 42, first paragraph. I'll again read. The auditee has submitted the reply to the observation in which the auditee has stated the trade discount in GSTR 9.
A short payment of tax, let us see
Lordship,
page
short payment of
41.
tax. Short payment,
Right.
Lordship, page 41. The auditee has discharged the tax liability amounting to this during April 18. The auditee has disclosed the remaining balance in 18-19 with applicable interest. So, Lordship, the observation was, we had submitted a reply that the difference that you are calling for has been paid by it in the subsequent
They
year.
have charged interest.
They charge interest.
They have charged interest.
Paid that.
Whether that payment of interest, okay, then they have now gone into new areas.
Lordship. And for the same period, when they have already closed it, the jurisdiction cannot,
Right.
the officer will not have the jurisdiction.
The issue is,
Yes.
firstly, subsection 7.
Lordship,
You have charged interest for that.
my lord,
Now they have paid.
Lordship,
But by page 48, you have gone into new areas now.
my lord, that is the case.
Whether you can do so. That is the question.
Lordship.
Page 46, my lord, they say, my lord, there are section or subsection under which the show cause notice is issued. It is section 73. So whether they can, my lord, subsequent to the audit report, whether.
That is what after 65.
73.
Lordship, 73. I will place 73. Lordship, may I please? Determination of tax not paid, short paid, erroneously refunded, or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression. Where it appears to the proper officer that tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than reason of fraud or any willful statement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax, which has not been so paid or which has been so short paid, or to whom the refund has been initially made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty liable under provisions of this act. Now, Lordship, kindly see the heading of this demand and recovery, chapter 15. Chapter 15 is demand and recovery, Lordship. Before section 73, the head note, Lordship. This is very important to note, Lordship. And how does this chapter comes, Lordship? Before that, there are 3 other chapters. Kindly come to, Lordship.
Let us read the
Okay,
provisions.
okay. I'll place the entire section, Lordship. The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. Where a notice has been issued for any period under subsection 1, the proper officer may serve a statement containing the details of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for such period other than those covered under subsection 1 on the person chargeable with tax. Subsection 4. The service of such statement shall be deemed to the service of notice on such person under subsection 1, subject to the condition that the grounds relied upon for such tax periods other than those covered under subsection 1 are the same as mentioned in the earlier notice. Subsection 5. The person chargeable with tax may, before service of notice under subsection 1, or as the case may be the statement under subsection 3, pay the amount of tax along with interest payable under section 50 on the basis of his own ascertainment of such tax or the tax as ascertained by the proper officer and inform the proper officer in writing of such payment. Subsection 6, the proper officer on receipt of such information shall not serve any notice under subsection 1, or as the case may be, the statement under subsection 3 in respect of the tax so paid or any penalty payable under the provisions of this act or the rules made thereunder. Subsection 7, where the proper officer is of the opinion that the amount paid under the subsection 5 falls short of the amount actually payable, he shall proceed to issue the notice as provided for in subsection 1 in respect of such amount which falls short of the amount actually payable. Subsection 8, where any person chargeable with tax under subsection 1 or subsection 3 pays the said tax along with interest payable under section 50 within 30 days of the issuance of show cause notice, no penalty shall be payable, and all proceedings in respect of the said notice shall be deemed to be concluded. Subsection 9, the proper officer shall, after considering the representation, if any, made by person chargeable with tax, determine the amount of tax, interest, and penalty equivalent to 10% of the tax or 10,000 which is higher due from such person and issue an order. The proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing of annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to, or within 3 years from the date of erroneous refund.
But this provision is not qualified by any other provisions.
Lordship, so that is the point. Lordship, show cause notice, this provision is the adjudication provision. Before, when, how to take an adjudication? What are the provisions of adjudication? This is to be read with Rule 142, which provides key natural justice. You have to give reply within 30 days. Order has to be passed.
Yes.
So, Lordship, this starts with demand and recovery. So, before the demand and recovery, the heading of the chapter, there has to be an audit, scrutiny, or an investigation.
Counsel, subsection 1 of section 73, where it appears to the proper officer, this is a tentative view. This is not a final view.
Appear, that is why it's a show cause.
If the representation submitted to be submitted by you satisfies the issue, then he will not proceed. Right. Question is that jurisdiction point you have issued,
Lordship.
that is not qualified by any other provision, section 73.
Lordship, because
I have read 73 now.
it's a provision which deals
It is
with,
a show cause notice.
Lordship, it's a show cause
Because
notice.
we are into a show cause notice, you are entering into the read process, jurisdiction, challenging a show cause notice.
Challenging that-
Remember,
I'm not
Remember.
challenging merits, Lordship. I am challenging the issuance of the show cause,
issuance of the show
Lordship.
cause notice, that is what?
not on the
You
merits.
remember,
Lordship,
all the point, all the time, you remember this is a show cause notice. Now this is 73.
Lordship, this
73 is not qualified by any other provisions.
it is not, Lordship.
Not.
It is not.
Then whether repetition is maintainable.
Lordship, then I will again kindly request your Lordship to come to 65.
65 is separate provision, 73 is whether 73 is qualified
Lordships,
or subject to the provisions of section 65.
Lordship,
Tell me,
Lordship,
yes or no?
Lordship,
That's all.
Lordship, just 2 I'll take 2 minutes.
Yes or no? Tell me.
Lordship, for yes or no, I have to just substantiate it with the why does the
No
legislature,
rider.
Lordship.
No means no, yes means yes.
Lordship, to my view, 73.
Because we are into not the final order.
Not
We
so-
are into a show cause notice. Tell me 73 is subject to the provisions is of section
No, Lordship.
65. No, then we'll
Lordship, so therefore, Lordship, section 65, when an audit has been conducted, and Lordship, can I rely
then
on
there is a provision to file show cause reply. Now, what is the law say? What the law says regarding show cause?
Lordship, but
Which
I am challenging the issuance of the show cause because 65(7) debars the officer to issue a show cause. 65(6) debars the officer to issue a show cause.
no, whether 73 is qualified.
Lordship,
This
we
is
have to
show
read
cause
both the
notice.
provisions together, Lordship. Then Lordship 65(7) will become ETIOS. It will become ETIOS, Lordship, in my case. 65(6), 65(7) will become redundant in my case, Lordships.
This is a show cause notice only.
Lordship, and I'm challenging that the person who has issued the show cause couldn't have done because of 65(6) and
Now
7.
73.
Lordship, 73.
This is detection of some other things.
Lordship, 73 as
How
I,
it is qualified?
Lordship, I am telling Lordship, kindly see 65.
Show me any authority.
Lordship, I have a judgment of the division bench of the Calcutta High Court, which has stayed the proceedings of scrutiny after the audit was conducted. Lordship, I brought,
Which part?
Lordship,
Which part?
no, I have brought one judgment, Lordship.
You have annexed something.
Lordship, that is on natural justice, Lordship. I am not referring to that as of now.
There cannot be any question of natural justice. Here, so-called notice.
Lordship, that
It shall be the natural justice.
Jharkhand High Court judgment, I have certain points. Can I place this one judgment with your Lordships? It's an interim order wherein the division bench has stayed the proceedings for the same period after an audit was conducted by the audit department and the issue was closed and all the payments were made. And subsequently for the same period, another proceeding by the nature of under section 61 and 73 was initiated. So the second proceeding has been stayed for the same period. May I place this with your Lordships?
Yes.
Lordship. Lordship, I'll take you to the starting, Lordship, because the facts are there in the beginning. This intra-court appeal has been directed against the order dated 3rd July in WPA this, by which the London single bench was not inclined to grant any interim order. Aggrieved, the appeal has been filed. We have already, the question in the instant case would be, as to the respondent authority can proceed further pursuant to the notice dated 17/4/23 purported to have been issued under section 61 of the Act.
What is 61?
61 is scrutiny of return, Lordship.
We are not into 61. We are into 73.
Lordship, I'll just take you to that only in the order. The appellant's case is that for the very same period, the audit department had issued a notice dated 5th April 21 and called for several documents which are submitted by the appellant. And after being satisfied, the documents pledged, the audit department has closed the case and approved the proceeding dated 25/3/22. It is further submitted, but for the same period.
Now, Mr. Counsel,
Lordship.
the very audit observation has made it specific that this is not a show-cause notice.
It cannot be, Lordship.
So it is merely an audit observation.
Lordship.
Right.
Lordship.
So you responded to it.
Lordship.
Right. Then accordingly, he had dropped.
Lordship.
So there was no show-cause notice
No show-cause notice.
in
Because
your case.
in 65(7) says that.
Let us see.
Lordship. 65, I will place 65
Paragraph 6 of your judgment.
of the judgment, Lordship. It is further submitted that for the same period, the DGGI has already issued summons and the appellants have submitted documents.
Has issued a notice. Paragraph 6
Lordship.
has issued a notice.
Paragraph
The
6,
order you have placed.
I'm reading from the starting again, paragraph 6. The appellant's case is that the very same period, the audit department had issued a notice dated 5th April 21 and called for several documents which were submitted by the appellant, and after being satisfied, the documents pledged, the audit department has closed the case and has approved the proceeding dated 25/3/22. It is further submitted that for the same period, the DGGI had already issued summons and the appellants have submitted documents and the matter is pending before DGGI. It is submitted that section 61 of the Act deals with scrutiny of returns, and in terms of 61(3), in case no satisfactory explanation is being furnished by the SSC or the SSC claims to take corrective measures in a return, the proper officer may ensure appropriate action, including those under 65. This having been done and the audit department being approved and settled the matter by order dated 25/3/22, the superintendent CGST L1 Circle 3 will have no jurisdiction to issue notice dated 17/4/23, which was impugned in the writ petition. Further, the appellant's case is that another question is a jurisdiction of the DGI to call for appearance, and they have submitted their jurisdiction and supplied all the documents called for, and the matter is pending. Furthermore, it is submitted that the notice dated 17/4 issued by the superintendent, the documents which have been called for are identical and the same settled by the department, which were called for by the audit department, which were furnished, considered, and the audit department has been approved and settled. And therefore, it is a case for the appellant that notice under 17 dated 17/4 is without jurisdiction. The London Standing Council appearing for the respondent submitted that directions have been received from the analytical wing of the department, and this necessitated the superintendent to issue notice dated this. In any event, a legal issue which has been required to be considered is whether a fresh notice would be issued by the range officer. The scrutiny of return had been done by the audit department. An audit has been conducted which has resulted in an order under 65. This being a jurisdictional issue, the court is inclined to pass the following order, which will be enforced till the writ is heard and disposed. In the result, the appeal is allowed. For the reasons stated above, the notice issued by Superintendent Durgapur dated 74 shall remain stayed till the disposal of the writ petition. The respondent is directed to file affidavit and the directions. So, Lordship,
Not the final order.
the exact case in this was an audit was completed, section 65. There also ADT 2 issued, I made the payment, matter closed. Again, the proper officer issued a notice under 61 read with 73.
On the very same issue.
On Lordship, in my case, 2 issues, same period. It was in this case.
Period is same.
It's also same period, Lordship.
No, here is the very same issue. The very same issue
In that case,
in Jharkhand.
Lordship, in Calcutta, same issue.
This one, this
This
one.
is Calcutta.
Calcutta,
Same
very
issue.
same issue. Very same issue which has been closed.
And my case also, Lordship, turnover and taxes paid, both closed.
Here is a case from the notice. It appears that some additional issues.
No, Lordship, I'll again take you. Kindly come to page 27 first, Lordships. Kindly come, Lordship. Page 27. Lordships. I'll read from the starting, Lordship. In course of the conducting the audit of accounts and records of Messrs. This, for the period July 17 to March 18 on 22 and 29/5/23, the following irregularities, discrepancies have been noticed, and the same is being informed in terms of Rule 101 of the rules. Number 1, short payment of tax in GSTR 9. I stop here, Lordship. That next table I need not read. The first issue is short payment of tax. Now, Lordship, kindly comes to page 46, page 48. Page 48, Lordships. Serial number 1 and in bold. Under declaration of output tax, the same issue for the same period. The same issue for the same period, Lordship.
Now tell me these figures, 48, these table figures were under consideration in the previous.
Lordship, now,
previous all these.
Lordship,
This,
no,
I can understand page 48 table.
Lordship.
First one, tax on taxable supplies as declared in GSTR 09, right?
Lordship,
This figure
matches.
Now, whether other figures were under consideration in the other
Why it was under
previous
consideration?
observation,
Why it was under question? I will show you, Lordships. Kindly come to page 29. My reply to the audit memo. All the figures were under consideration, Lordship.
no, you have submitted that.
And therefore,
But-
it was considered and dropped. Therefore, it was considered and dropped by the
What is
audit.
the drop?
Lordship, page 41, Lordship. Page 41. Out of the first point of 32 lakhs, they have only confirmed me the interest because they say you are reconciled. Para number 1, Lordship, page 41, I will place again. Short payment of tax. The auditee has discharged the tax liability amounting to this during April 2018, which is the next financial year. The auditee has disclosed the remaining balance out of the 32 lakhs in 2018-19 with applicable interest. Hence, the objection is ignored. The same issue, short payment of tax, the objection is ignored.
That is regarding the first row of the show cause notice.
That is regarding the first row.
First row.
I bow
What
down to your
about the
lordship.
others?
I bow down to your lordships. Coming to the second point of the show cause. Input tax credit, lordship. Now, input tax credit, my lordship has seen definition of 2 subsection 13. I'll again place section 2 subsection 13, lordships. Audit means examination of records, returns, and other documents maintained or furnished by the registered person under this act or the rules or under any law for the time being in force to verify the correctness of turnover declared, the taxes paid, the refund claimed, and the input tax credit availed, and to assess its compliance. Lordship, when the audit had happened, my entire input tax register was before them with the invoices copies, and they found no ineligible credit which I have availed. They found no ineligible credit which I have availed. And this proper officer, basis of figure work, has attained certain liabilities without asking for any documents. An audit is conducted, Lordship, wherein physical documents are provided to the officers, Lordship. GSTN 9 does not contain any documents. It is only numerical figures, Lordship. So basis numerical figure, they have raised an objection that this is ineligible credit. And where the same wing has already completed my audit and no observation for input tax credit because they were satisfied with the documents provided, Lordships. So, Lordship, the only point which I raise in this petition before your Lordships is that section 65, 6 and 7 clearly provides that when an audit is conducted.
Mr. Counsel, we are on the so-called notice,
Lordship,
not in a final order.
I'm on with the show cause. So the issuance of show cause is under the challenge, Lordship.
Now, where does 73 says?
73, I'll again take you to 70, Lordship.
73 subsection 1 does not say anything.
Lordship, it is a provision of demand and recovery.
It is very tentative view. Subsection 1, 73,
Lordship,
where it appears.
Lordship.
It is a tentative view and you know about the.
Therefore, it's a show cause notice,
show cause
Lordship.
notice.
Therefore, it's a show cause.
Show cause notice.
But Lordship, my case is when an audit is completed and I have closed down all the paragraphs, this show cause cannot be issued. That is what your Lordships has seen in 65, 6 and 7. I am on that point, Lordship. I am not on the why, where from this show cause has come. How can this show cause come? Whether the jurisdiction of the officer to issue a show cause after an audit has been done. That is my limited challenge before your Lordships. Lordship, 65, 6, I'll again place Lordship. 6 and 7.
Is it not a premature stage?
Lordship, it is not, because jurisdiction is something, Lordship. If I accede to this jurisdiction, I will have to participate till the tribunal. I will have to participate until the tribunal, Lordship, because suppose I go accede to the jurisdiction, I reply, and they pass an order, I have to go to appeal. I cannot come after the order.
Yes, Mr. Gogoi.
On the jurisdiction part, my lord, yes. Lord, we will keep it open and let me have the instruction, my lord, because my lord, this so cause notice was to be replied by 28/10. By this time, if any final order has been passed, ex parte order, I can't say, my lord, as on that without instruction. So let me have that instruction, my lord, on Friday in that case, my lord.
Okay, Friday.
Lordship, I am from outstation. I am from Calcutta, Lordship. Can I seek, my Lordship, my learned friend is filing an instruction, only instruction.
Written instruction.
Lordship, till that time protection may be given to me. Because Lordship, what has fallen from my learned friend also, Lordship, to be very true to your Lordships. Last day to file reply was 28th of October. Lordship, it has passed. I had filed a writ before that, but because of the Puja holidays, because therefore it is on the first day after the holidays, Lordship. Till my learned friend files a reply or an instruction, whatever my learned friend wishes, I am not opposing, Lordship. I may be given interim protection because if they pass an ex parte order, my writ becomes infectious, Lordship. Till that time.
Whether till date it is filed or.
Till date only.
Till
yes.
date only.
Yeah.
If something has been passed already.
No, it has not been. Till today morning, I have seen the portal, Lordship. It has not been. Had it been, I would have placed before your Lordships.
Then on my lord, Friday, my lord, at least let me have the instruction from the authority on the merit of the case on this point. Whether, my lord, we can.
On the jurisdictional issue only.
Yes, under 73.
Whether 73 is independent of section 65. That is all.
Yes.
Lordships is placing this on 10th. 10th would be okay, Lordship. I'll come down on 10th, Lordships.
It will be a book for tribunal. Okay. 13 is holiday. 15?
15th I can come, Lordship. I can.
Mr. Gogoi?
My lord.
15?
My lord.
Okay, heard Mr. A. Kanodia.
Lordship.
Not a counsel for the petitioner. And Mr. B. Gogoi, standing counsel, finance and taxation.
Yes, well.
For all the respondents.
All the respondents.
The petitioner has assailed In this repetition, the petitioner has assailed a show cause notice issued purportedly under section 73 of the
Assam State GST, Assam GST and CGST Act.
okay,
CGST/AGST, Lordship.
of the Central Goods and Services Tax Act 2017 stroke
Assam Goods and Services Tax Act.
Assam Goods and Services Tax Act 2017. On the ground that the noticee did not declare correct tax liability while filing the annual returns of GSTR-09. What is the date of submission of
Lordship, in the next page,
page
47.
40?
47.
Okay.
Description, date by which reply has to be submitted is 28/10.
The petitioner noticee was asked to submit its reply by 28/10/2023. First up, Mr. Kanodia, Learned Counsel for the petition, has submitted that a show cause notice purportedly under 73, section 73(1) of the CGST stroke State GST Act is issuance of is not tenable in view of the fact that an order under section 65(6) of the Central CGST Act 2017 stroke Assam GST Act 2017 has already been issued under form GST ADT-02 on 17/6/2023. Since an order under section 65(6) has already been passed, issuance of a show cause notice under section 73(1) is without jurisdiction. Mr. Gogoi, Learned Standing Counsel, Finance and Taxation, has sought for a week's time to obtain instruction as regards the legal issue raised in this petition. First up, lays the case as sought for by Mr. Gogoi, lays the case on 15/11/2023. First up, it is observed that if no, Mr. Kanodia has further submitted that as the petition has been preferred, challenging the jurisdiction to issue a show cause notice under section 73(1), the petitioner has not yet submitted its reply in response to the show cause notice on or before 28/3/2023. Mr. Gogoi has further submitted that he will obtain instruction as to whether any order has been passed subsequent to 28/10/2023 ex parte. Having regard to the issue involved in this litigation, it is observed that if no order has been passed on or on 28/10/2023 or subsequent thereto, comma, there shall not be status quo as on date be maintained. Status quo as regard the proceeding shown stated to be drawn up while the so-called notice dated so and so be maintained till the next date of this.
Grateful.
Item number 6.
Yes.
Lordship, here petitioner is claiming ex gratia as per notification 15/11/14.
Yes, Mr. Sharma, will issue notice or what?
Lordship.
Okay. Mr. M.R. Khandoka, Learned Counsel for the petition. H. Sharma, Learned Additional, any state, N. Bodole, Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. Any finance, Mr. Gugoi, B. Gugoi, Standing Counsel Finance Department for the respondent number 2, and
3
Mr.
to
H.
6.
Sharma, Learned Additional Senior Government Advocate, Assam for the respondent number 3.
3 to 6.
3 to 6. Full stop. It is the case of the petitioner that the petitioner's father died of injuries sustained in a road traffic accident on 4/10/2020. 4/1 occurred at a public place.
Next to kin
Full stop. By this writ petition, the petitioner has claimed ex gratia in terms of the notification dated 15/11/2014. Issue notice returnable.
May I point out one thing, Lordship? They have not annexed the NOK, Lordship. Next to kin certificate is not annexed here. If it is, if they have not submitted it before the authority, they are not entitled to.
Okay. Mr. Sharma, Learned Counsel for the petitioner, has submitted that the next of kin certificate has not been annexed by the petitioner in this petition. So issue notice returnable on December 8/12/2020 as so and so appeared accepted, no formal notice, extra copies within 2 working days. The petitioner may submit the petitioner. In the meantime, the petitioner is permitted to bring the NOK certificate by way of an additional affidavit.
Item number 7.
My lord, in this case, my lord, the petitioner is, my lord, belonging to a Chakma community. My lord, he is doing work for the betterment and upliftment of the Chakma community, my lord. And my lord, he
What the order you are challenging here?
my lord, first RTI application, my lord.
24/3/2023. Where is that order?
Yes, my lord.
Where is that order? 24/3/2023.
24/3/23. That is the second appellate.
Where is it?
order, my lord. That is, my lord, at page, your lordship will find.
28 for Lordship.
28/4.
That is at page 32.
Page 32.
Page 32 to 35.
32. Information sought for background. What is the total population of Sakma scheduled tribe as per record?
Yes.
What is the total population of Sakma scheduled tribe community as per record census? Supplied a photography.
Then
Supplied a
what is the total population of
difference is I have the honor to inform you that
clear copy?
there is no scheduled tribe Sakma.
Reference to the no scheduled tribe community. My lord, this is, my lord.
No, you have made queries
My lord, some queries, some
Four
information.
number of queries,
Absolutely.
right? And what is the reply?
My lord, reply your lordship will find at page with reference 33, my lord, with reference.
Let us see your first prayer.
Yes,
First query, what is the total
First
population of the Sakma scheduled tribe
yes.
community in Assam in 1951 as per record of page number for mentioned in volume in part? The reply is contained in the question itself. Let us read page 32. What was the total population of the Sakma scheduled tribe community in Assam in 1951 as per record of page number 419 mentioned in volume 12 in part 1A of census report of India 1951 of Assam, Manipur, Tripura?
Yes.
Is
there
it a
are-
question or is it an answer?
No, my lord, there are.
Huh?
Lord, the question.
Is it a
number-
question or is it an answer?
My lord, they have furnished.
You seek confirmation. Is it not?
Yes.
Huh?
The total.
Confirmation.
Total population
No,
of.
there is
Chakma
no
community-
scheduled tribe.
Total population of Chakma community, yeah, page number 5. What are the?
They
total-
replied.
As per census report 1951, Assam Manipur reply clearly in writing.
Clearly in writing. They have
My
made
lord, they
clearly in writing.
My lord, then my lord, the what was?
Let
the
us see
total-
page 33. There is no scheduled tribe, namely Sakma, in 1951,
Yes.
according to the Constitution Scheduled Tribe Order 1950.
That is contrary to page, my lord, what they furnished in page, my lord, page 64. Page 64 is the, my lord.
Page 64, okay, 64.
But before that, my lord, your lordship kindly come, my lord, page 49. Page 49. Page 49, my lord, Chakma. It appears in serial number 15. From page.
So what is the exact issue here? Tell me.
Issue, my lord,
Huh?
that the residents of the my lord, Chakna community in different villages, different blocks, different, my lord, areas, and, my lord, the population there to, my lord. This was the information sought for by the petitioner, my lord. And that has
What
been
is the
not,
total? No.
my lord.
Read the query
Total they
first.
have.
Read the query first, Mr. Singh.
Yes,
What is the total population of the Sakma scheduled tribe
yes,
community?
yes,
First thing is that Sakma scheduled tribe.
my lord.
So there is a constitution order,
1950.
scheduled tribe order,
Yes,
1950,
1950.
and section 340, article 340 perhaps,
340, yes.
right?
Yes,
Whether the Sakma was scheduled tribe.
yes, my lord.
Where?
My lord, it is there in the,
Where? Scheduled, it is there, page 50.
page 50.
Nobody else except the government of India can declare a tribe as a scheduled tribe.
True, my lord.
This is as true as the position sun rises in the east. Now show me, Sakma, where is that?
My lord, this is 1951 census, page 45.
We will not go into census. We will go into the constitution of scheduled tribe order. Where is that?
My lord, that your lordship find, my lord.
Page 51, in the autonomous district of Karbi Anglong and North Kasai Hills, Sakma. Sakma is there.
Yes,
Is it not?
yes, my lord.
Then what more you want?
My lord, we want. that-
Whoever is there,
My lord,
why census?
my lord,
You have asked for some query, they have provided the query.
but not, my lord, that is income.
They
my
have
lord.
provided the query.
My lord,
Is it not?
They have partly, my lord, they have provided, my lord. They have not provided the entire, my lord, the complete information, my lord. That is the grievance of the petitioner, my lord.
What was the total population of Sakma scheduled tribe community in Assam in 1951?
My lord.
What do you want? You want confirmation or you want query? Don't confuse the two.
My lord, my lord, confirmation is there, my lord. There is no doubt,
No. Read the query.
my lord.
What was the total population of Sakma scheduled tribe ST community in Assam in 1951?
My lord.
And why you are referring to page 419?
It is there, my lord.
These are two things, mister.
My lord. My lord.
Don't ask me to tell your intention. You ask specific query. What is the Right to Information Act, Mr. Sen?
My lord, I
You
have-
either make a query
My-
or you either make a ask for documents.
No,
You either make a query or you either ask for information. What is information?
Information, my lord.
No, it is not confirmation.
It is information, my lord.
It is not information.
It is information, my lord. that
What is the
the
total population as per so and so, so and so?
Yes. And my
Okay.
lord, then
What
my
they
lord,
reply? Page 419.
reply is the next page, my lord.
Ah,
Your lordship
what is
will
it?
find There is no scheduled tribe. My lord, page 33. There
Ah.
is no scheduled tribe, namely Chakma in 1951. According to the constitution,
So what is wrong?
my lord, wrong is 1950. Your lordship kindly see the 1950 page 39, my lord. There is, my lord, the constitution.
No,
schedule
419 mentioned.
My lord,
Wrong information. What is your case exactly?
my lord, I have sought for certain information, my lord.
They have provided.
They have not.
They have
My lord,
provided.
my
Page
lord,
33.
no, my lord,
Maybe wrong. That is a different issue.
my lord, no, my lord, thereafter, my lord, we have also sought for information regarding, my lord, the residential area.
Mr. Sharma, what is the case? I have not understood ABCD of it.
The
My lord,
queries that
we-
has been replied, lordship, the query which was put, that was replied.
Now, what is the
If your lordship.
power of judicial review?
Lordship, if your lordship comes to page 15, that is the prayer portion. According to my learned friend, that the information which was sought for, that was incomplete, the reply. But in the prayer portion, lordship, he is praying for setting aside of this. Lordship, I am also.
Because that is not correct information, my lord. Incomplete information, my lord. The residential area of the Chakma community is not there in the information
That is
that
not
has been
his
provided.
query also,
My
lord.
lord, that is my query. Your lordship kindly see. My lord, the first page 19, my lord, the first RTI application, my lord.
Lordship, the councils.
Mr.
Department.
Sharma, you go through it. We'll
No, lordship,
take it up
because the.
some other day. If this is not to be a case, we will not issue any notice.
Lordship, I am appearing for only one respondent number 4, State of Assam, but
My lord,
whether this copies has been served upon them or not.
Central government?
I am appearing here as,
Yes,
my lord,
yes.
legal aid counsel, my lord. In this
Legal aid
case,
counsel.
my lord, in this case. So, my lord, there, my lord,
Central government has been served or not? Where is Central Government Council?
They are the appropriate councils, lordship.
Mrs. Again is in Lakes, Lord.
Huh?
Mrs. Again is in Lakes. I'm calling her. I may be allowed to call.
Call Mr. R.K. Dev Chaudhary. List doctors
I'll-
on Wednesday,
on Friday, my lord,
not
Wednesday,
Friday,
sir.
Wednesday.
Wednesday, I
Uh,
have some, my lord, preoccupation, my lord.
We have also problem on Friday. Monday then, Monday is holiday,
Tuesday or Wednesday,
Wednesday,
Wednesday.
next Wednesday.
next Wednesday. Yes, MS Gayan. Why you were absent?
I was in court number 3, my lord.
Yes. What is this case? He is challenging an order of the Central Information Commission,
Yes.
right?
Yes, my lord.
Delhi. Mr. Sharma, what is this case about?
Lordship, that is why, Lordship, I am also raised his
He has asked for queries
Lordship.
and
that was
information.
provided,
Information provided by all the forums.
Lordship.
And whether we are going to decide right or wrong of the information.
No, my lord. What I am submitting, my lord, that the information that I have sought for has not completely been furnished to us, my lord. Number one, they have furnished
Okay,
the.
only issue.
My
Okay,
lord,
only issue notice then.
my lord.
Heard Mr. B.K. Shen, learned legal aid counsel.
Yes.
For the petitioner, MS A. Gayan, learned central government counsel for the respondent number 1, 2, 3. Mr. Sharma, you appear for?
I am for 4, Lordship.
And 5, 6?
Chief Lordship.
Deputy registered
Census operation, Assam. I don't know.
Assam, my lord. Yes, my lord.
I don't know.
Yes, my lord.
Either you or Mr. Sharma.
I think Mrs.
I think
Gandhi.
yes, my lord. We are similar central government, under central government. I think
Okay,
this one.
5 and 6. And Mr. H. Sharma, learned additional senior government advocate, Assam for the respondent number 4. Full stop. By Mr. Shin, learned legal aid counsel, by referring to the judgment. Judgment or order? Page 32.
Page 32.
Page 32, my lord.
To the order dated. What is the date?
Page 6, 2022.
24/3.
20
Date of decision,
28/4.
28/4/2023. Passed in second appeal, page 32. CIC stroke M home stroke A stroke 2022 stroke 127/172, page 32. Passed by the Central Information Commission, New Delhi, has submitted that only issue raised in this petition is that the information supplied to the petitioner in respect of 4 number of queries sought for by the petitioner under the provisions of the Right to Information Act 2023 were not supplied completely, as the information supplied to the petitioner were only in part. The petitioner has preferred the instant petition. Full stop. As so and so, issue notice returnable in 4 weeks, as Ms. So and so appeared and accepted, no formal notice, extra.
Petitioner died by drowning, my lord.
Heard Mr. M. Hussain, learned counsel for the petition. N. Bordolo, pending counsel revenue and disaster management department for the respondent number 1, Mr. H. Borua. Learned counsel representing Mr. B. Gogoi, learned pending counsel finance department for the respondent number 2, Ms. M. Bormon. Learned senior government advocate Assam for the respondent number 326. It is the case of the petitioner is that the petitioner's daughter died due to drowning on 30/9/2021. And the incident, it is projected that the incident of drowning had occurred due to accidental or due to heavy rain and hurricane. Full stop. Claiming ex gratia amount. Is there any policy?
Yes, my lord, 1511, my lord. In a public place, my lord.
Okay. Claiming ex gratia in terms of the notification dated 15/11/2014 of the Revenue and Disaster Management Department, the instant writ petition has been preferred as so and so appeared, accepted, formal notice, extra copies within 2 working days, issue notice, returnable in 4 weeks.
Obliged.
Item number 9.
Yeah, please, Your Lordship. My lord,
Yes.
this is the second writ petition filed by the same petitioner, my lord.
Hmm.
In earlier occasion, writ petition was filed challenging the appointment and selection of the respondent number 4 on the ground.
Respondent
of
number
violation-
4.
Yes, my lord.
What is the ground?
In this ground was only one ground, the condition number 3 of the advertisement violation.
Advertisement.
Yes,
Okay.
it is annexer 1 at page 29, my lord. Type copy,
Annexer one. Original one. Page 30.
page 29, my lord.
Original.
Original 30, yes.
What is the post?
Post is, my lord, the peon, my lord. Is a total
Peon.
Peon. Total 4 posts were advertised.
Huh.
2 were open for general, 1 was for general SC and 1 was for OBC. And another 1 post that is for Chokidar, that I am not concerned the Chokidar post, I am concerned the, my lord, peon post.
4 existing manager peon.
Yes, ma'am. Scheduled caste.
One is OBC, one is scheduled caste, and remaining is open. You are open.
I am, my lord, scheduled caste.
Scheduled caste.
Yes, ma'am.
Okay, 4 posts of peon, one is scheduled caste.
Yes, ma'am. I am for
Before in the office of the CGM.
CGM, my lord.
Jorhat.
My lord,
Eligibility
my lord.
criteria.
Criteria, three eligibility criteria, where it is specifically, my lord, mentioned in
Okay.
that a candidate who has passed the class 9, 8, but not passed class 12. Candidate who have passed class 12 are ineligible to apply.
Okay.
So that was my condition, that the respondent number 4, subsequently I came to know that he was already passed graduation, and he much earlier he obtained the higher secondary.
Where is it? Any evidence?
Yes, that was, my lord, I done. But initially I filed a complaint, and on the basis of that, my lord, the CGM directed to me, my lord, the proof of, to submit the proof of this, all these allegations. Accordingly, I have filed the RTI before the, my lord, secondary council, and they have provided all the information, then I submitted.
Where is that?
That is, my lord, it is in annexer. Page 47, my lord.
Page 47.
Yes, ma'am.
Which part?
This is.
What is his name? Sanjay Kumar Das.
That's my lord. Another also, my lord, but they.
He passed 2001.
Yes, my lord.
Higher secondary.
Higher secondary.
Okay.
And the rule number also given, and the central code also given, my lord, central name
Okay.
also there. And the second, my lord, the another candidate, the second one, this, my lord, Vaikuntha Das. Well, he was in waiting list number 1. I was in waiting list number 2, my lord. So 1 was selected, Sanjay Das. And if, my lord, his qualification also more required than this advertisement. And the first one in the
He was appointed.
He was appointed, his drawing salary, everything well. Then, my lord, lordship has passed an order on, my lord, I approached earlier occasion. This is lordship will get at page 51, annexer 7. Where, my lord, the lordship was pleased to pass a direction. Kindly turn to, my lord, page 53, clause para 7, my lord. Accordingly, without expressing any opinion on merit, this court is inclined to close this writ petition by granting the liberty to the learned Chief Judicial Magistrate Jorhat to conclude its inquiry and pass and complete complaint and based on the complaint made by the petitioner dated 25/1/2021 and the follow-up letter dated 12/3/2021. In the same regard, it is provided that the learned Chief Judicial Magistrate Jorhat shall allow the petitioner as well as the respondent number 4 and 5 an opportunity of being heard and thereafter pass appropriate order in accordance with law. In the event the matter is still, petitioner is still agreed, he shall have the liberty to approach this honorable court. So here, my lord, what happened? After this order, my lord, we have submitted the order and accordingly inquiry is completed. Total, my lord, total, my lord, 6 days, my lord, hearing was concluded and including 3 witnesses were examined. Then after that, they were finally on 25/4/2023 came to the conclusion that this is, my lord, already concluded and as per my information, then, my lord, I went to the office. Then I have been informed that it is concluded and it is proved the allegation against the, my lord, respondent number 4. But no, my lord, communication was made to me. So therefore, my lord, I have filed an RTI application. So by this, my lord, RTI, the lordship will get the reply. They have filed the annexure 12 at page 65. The relevant portion at 66. The reply 5, my lord. Reply. The departmental proceeding have been initiated against Sri Sanjay Kumar Das, peon of the Office of the Subdivision and Judicial Magistrate M. Titavar, and Srimati Uyusri Sarvan, learned Judicial Magistrate First Class Jorhat, is appointed as an inquiry officer to conduct the inquiry under Rule 9 of the Assam Service and Discipline Appeal 1964, and Srimati Sultana Naslin, learned Judicial Magistrate First Class Jorhat, is appointed as a presenting this case before the inquiry officer in respect of the matter, my lord. Well, my grievance is this, my lord. It already, my lord, in complying the honorable court order, inquiry is completed. Witness were examined. And that took, my lord, 23 months to complete the entire proceeding, my lord. So now, my lord, if the again going for this departmental proceeding by initiating this proceeding, my lord, then my lord, what will be my lord, grievances that will be never sustained, my lord?
There was an advertisement.
Yes, my lord.
4 posts of peon.
Yes, my lord.
One is reserved for SC.
Yes.
You competed for that scheduled caste post. This respondent number 4 also competed for scheduled caste post.
Yes, ma'am.
Of peon. And this respondent number 4 is class 12 pass.
Yes, ma'am.
Whereas the advertisement mentioned that a class 12 pass candidate cannot, is not eligible.
Yes.
Was not eligible.
Yes, ma'am.
So that is the issue.
Yes, my lord. And if so far the respondent number 5 is concerned,
So
he
far
already-
departmental proceeding is concerned, that is between employer and employee.
Yes, my lord.
We cannot, on the basis of your writ petition, we cannot interfere.
Yes, my lord.
But question is that respondent number 4 is ineligible.
Yes, my lord.
That is as per the advertisement.
Now,
That
my
is
lord-
the question.
Yes, my lord. Now it is.
So his appointment is liable to be cancelled.
Yes, my lord.
That is your case.
Yes, my lord. And so far
Because
in
they are free to do anything
Sir, I
as
am
an
not-
employer.
I am not that.
We are not into page 66, question number 5.
Yes, my lord.
They may do so.
Yes, my lord.
But your question is that he was ineligible to be appointed.
It is already by inquiry, it is, my lord, proved, but they came to the conclusion.
Yes.
So now, my lord, one pair, my lord, this, since he is enjoying the, my lord, the salary. So if it-
Let him enjoy. We'll consider this writ
Yes,
petition.
my lord.
I'll obtain instruction.
In the meantime, you file your response. That's
Yes,
all.
my lord.
Not instruction. It has to be decided.
My
What is the law?
My lord.
What is the law otherwise?
Otherwise,
Suppose-
I searched the law, my lord, there is no specific law as I found that he cannot proceed against the, my lord, so far the departmental proceeding is concerned.
No. That suppose an advertisement
Yes.
has prescribed that a person having this qualification is not eligible to apply. Whether that kind of advertisement is sustainable
My lord, so far, my lord, the recent, all the advertisement, my lord, comes under judicial department, my lord. It was specifically, my lord, mentioned, the so far, my lord, the peons and other categories.
Yes.
Yes, my lord.
Suppose, now question will be, if suppose there are many posts of, say, we have seen in newspaper reports
Yes, my lord.
for the post of constable in Bombay, Maharashtra, 8,000 candidates ran for 100-kilometer race. Out of that, there are about 50 PhDs,
Not only Bombay, then Guwahati
200
also.
engineers,
In Assam also.
100
happening.
doctors also.
Assam also happening, my lord.
Doctors,
Yes.
PhDs, and engineers. They are running 1-kilometer race for the post of constable. Now, if they get the post, whether because this kind of qualification is prescribed, that class 12 candidate is not eligible to apply. What is the law?
The law is, my lord, so far the terms and condition of the advertisement is, my lord, specific. But by violating that. my
Any
lord, they-
authority?
My lord, I will come to Lord that authority, my lord.
Or you will
they have
decide about the law later on.
always stick to the my lord, advertisement, my lord.
In the future, we'll decide.
No, my
You are
lord.
not.
My lord, in earlier.
You are not in possession of any authority.
Yeah, my lord, right now I'm not.
No.
My lord. But so far, my lord, I know, my lord, this is a specific, that is a direction.
Heard Mr. P. Mohanto. Then this waiting list candidate is not a party now.
No, yes, he already, my lord.
Operation might be successful, your patient will be dead. Heard Mr. P. Mohanto, learned counsel for the petitioner.
He has already abandoned.
MS S. Sharma. Huh?
The waiting list, my lord, candidate, he abandoned the claim, my lord, in earlier proceeding on. He is claiming already here.
Yes, MS Sharma, you appear for?
1, 2, and 3, my lord.
Okay, MS S. Sharma. As a standing counsel or as a?
Standing counsel of.
No, it cannot be standing counsel.
One I met.
Earlier High Court.
Guwahati High Court is not made a party.
No.
I think,
Cause list doesn't show.
I think it should be.
Yes.
I think Mr. Mohanto
My lord.
case might suffer because ultimately every appointment is processed.
I will, my lord, make the party.
No, then in that case, you have to file amended cross title.
Okay, my lord, I'll file it.
I think, I don't know. Otherwise, I can issue notice.
I will file it.
No. If you want to file, you have to file.
Yes, my lord.
We will post it on another date for amended cost title. Nowadays, Mr. Mohanto, we have to file amended cost title as per the notification.
Yes, yes.
So we will stop here or should not stop here.
My lord, there may be postponed, my lord, I'll file a amendment.
Notification. No? Heard
Friday, my
Mr. P. Mohanto, learned counsel for the petitioner. Mr. Mohanto, learned counsel for the petitioner, has submitted that he will file amended cost title in terms of the notification dated so and so in order to implement additional respondent within a period of.
My lord, I'll file, my lord, tomorrow, my lord, that may be listed day after tomorrow, my lord.
By within 2 days, list the case on Friday.
Maso.
Okay.
Maso.
Amended cost title. Huh?
Item number 10.
May I please ask? My lord, I am the registered owner of a land of measuring, my lord, 10 lassa, my lord. I went several occasions for demarcation of land. my lord.
Registered owner of a plot of land.
Plot of land measuring 10 lassa.
10 lissa.
10 lassa, it's subjected to various cases, my lord, for my demarcation, my lord. Lordship will see, my lord, at page annexure 3, my lord, at page 20, my lord.
Huh.
The middle portion, my lord.
You are Bajrang Agarwal?
Yes, my lord. The partitioner so appeared in the understand and submitted a hajira. The dispute over the house has been logged by the second party. The first party claims the house is rightfully. There is a land in which the house belongs to first party. During the hearing, it was found the second party requested the concerned circle officer to do needful to do land demarcation so that the dispute may solve. The first party does not allow the circle authorities to do so much. So if the demarcation is being done, my lord, it will take its own course, my.
Hmm?
If the demarcation is taking place, my.
What is 107?
107. Thereafter, another report, my lord, was furnished at page 24.
Appear dispute is over a house that has been logged by the second party. First party can house is rightly there as a land.
Thereafter, my lord, another report has been submitted at page 21. Operative part is the page 22, my.
Report.
Yes.
Let us read the report.
Back to state that as per the direction of the reference, after a record inquiry came to know that the land measuring 11 latches covered by DAG number so and so DAG number patta number 370 or DAG number 370 recorded in the name of 10 Lassa Vishnu Saha Binda to Ramnath Saha, son of late so and Devi so number 4 and Avijit son so. After physical verification, it came to know the 11 lasses there is a house oblique home. The land remained vacant, though the said land someone constructed a welding gate in 2009. It came to know that Sri Hanuman Agarwal, that is the petitioner, later on locked the said welding gate, and because of the man left and the said shop. The part of the said Niyadi Patta land, Das Lasa so and so number, registered deed Hanuman Agarwal, son of so and Ghosh so and Chandra Ghosh, son so Lamlal Ghosh, and also taken position from the seller of covering wood stick and tin fence. It came to know that though the absence of the Hanuman Agarwal, the son of Fulchan Agarwal, the said fence and stick was removed by the patta holder Srimati so Saha Binda Ramesh Saha Binda so in the year 94. The time of the Hanuman Agarwal, son of Fulchan Agarwal, lost the case before the Fakiragram police station against the persons who removed the fence. Hanuman Agarwal, son of so prayed for a mutation and possession of the 10 lassas of land covered by so. That is it. Only, my lord, demarcation is being done, my lord. Or may I make one submission, my lord? I'll make a press representation to the authority concerned, my lord. Under the supervision of the deputy commissioner, by speaking order, my lord, let them do the needful, my lord. That will suffice the dispute arising out.
Your first prayer is for mutation.
Mutation and demarcation also.
If the plot of land is disputed,
my lord, if the no demarcation is being done, my lord, no further process can be proceeded.
but if the demarcation is a process, if it is a disputed one, then
my lord, he restrained, my lord, for demarcation, my lord.
so apparently 107 means there is something about possession.
Yes, my lord.
And if it is possession, dispute about possession, then demarcation is a difficult issue.
That's true, my lord, but
that process,
so from the record, it reveals, my lord, two things were sought for by the petitioner.
because
One
what
for a
cannot be
mutation-
done directly cannot be done indirectly.
Yes, my lord.
If the 10 lassers plot, there is dispute about the possession of the petitioner, then the process will be for confirmation of possession first.
Yes, my lord. By the way, but at this stage, my lord, I'm.
So that is a matter of civil domain,
My lord.
Yes,
is it not?
Yes, my lord. At this moment, I'm.
So knowing about that situation, there is a process under right to, I think, Public Services Act for demarcation.
Yeah.
You prepare an application. Then if the circle officer does not do it, then there is an appeal before the deputy commissioner. Then thereafter, before the Board of Revenue, perhaps.
My lord.
Is it not?
Yes.
I think because since the pure position is under a
My lord,
cloud,
position is not exactly cloud, my lord. He has broken
something
out my.
about position, something is
He
there.
broken out my wall. And I approached to the authority for.
Because 107 proceeding indicates
something is there.
something is there.
Yeah.
So you may not have the clear position. If you have the clear position, circle officer can proceed and demarcate the land.
Right.
So we are not going into that dispute. We can simply observe that you can, you
Yes,
prefer
my-
an application
my-
before the
That
circle
observation,
office.
that observation be given to me, my lord, to approach before the authority, my lord, by way of fresh representation or application that.
Press application as per proper procedure.
Lordship, like time limit be given, my.
These are notified service, your lord.
Notified service, let us see demarcation.
Apply accordingly.
Notified service.
Only, my lord.
Some demarcation or asani. Heard Mr. J.I. Borbunian, Learned Counsel for the petitioner. M.S.N. Bordoloi, Learned Standing Counsel, Revenue Department for the respondent number 1. Mr. R.K. Mushahari, Learned Counsel, Standing Counsel, PTC for the respondent number 2 and 2 and 5. And Miss S. Sharma, Learned Counsel for the Learned Junior Government Advocate Assam for the respondent number 3 and 4. Full stop. In view of the submission made by Mr. Borgwell, Learned Counsel for the petitioner, the writ petition is taken up for disposal at the motion state itself, as there appears no necessity to issue notice to the respondent number 6 at this full stop. Para. It is a case of the petitioner that by registered by a sale deed being registered sale deed number 390 dated 28/01/1972, the petitioner purchased a plot of land measuring 10 acres, covered by what is this? 169 paragraph 2. What is KMP 169? I don't know.
Patta number.
Huh?
Patta number.
Where is your sale deed?
Sale deed is, my lord, at particular at page 15. When measuring 10.
A plot of land located
covered by Satyan, tag number.
at village Pub Kutaghat, Dihi Des Pokiragram, Pochagar, Revenue Circle Des Dotma, Pokrajar, from its erstwhile owners. So the petitioner has asserted that since the date of purchase, he has been enjoying the possession of the subject plot peacefully. So, petitioner has also referred to certain proceedings drawn up under section 107, Code of Criminal Procedure between him and certain other persons, including the respondent number 6.
5. First 6.
Full stop. As Mr. Borvia, Learned Counsel for the petition, has submitted that as proper demarcation of the subject plot has not been carried out by the respondent authorities, despite request from his end, from the end of the petitioner, the petitioner wants to submit application for demarcation afresh, seeking demarcation of the boundaries of the subject plot, and thereafter to apply for mutation. Full stop. The Learned Counsel for the respondents have, in unison, submitted that the matters of demarcation and mutation also
Yes, your lordship.
are notified services under the Assam Right to Public Services Act, 2012. Full stop. So this office memorandum was there. How to go about it?
My lord,
What is the fees? What is the form? Everything is there.
I'll check it.
Okay, I'll pass the order. So paragraph 3, 4, 5. 6 or likhibo. In view of availability of an alternative efficacious statutory remedy, comma, the writ petition is not entertaining, reserving the liberty to the petitioner to avail the appropriate remedy available to him under the law.
On their failure, my lord, I can approach again. That
Under the law. It is already there. Right.
My lord, instead of entertaining, my lord, can be disposed of, my lord. At least some relief I'll get.
No, we are not entertaining consistently. Consistently, we are not entertaining. Reserving the liberty, we have already observed everything. If you want to check it,
I'll check it.
go to the order.
Yes.
If you want some modification, you can.
Lordship will pass it.
I would like.
Item number 11.
Hard MS. S. Devi.
Yes, on behalf of S. Devi, Lordship.
MS.
On behalf of S. Devi,
Your name, please.
No, Lordship, not in record, Lordship, because of his, her urgency.
Your name, please.
R. Wrong, my Lordship.
R.
Wrong,
Wrongmai, Learned Counsel appearing for MS S. Devi, Learned Counsel for the petitioner. N. Bordoloi, Standing Counsel Revenue and Disaster Management Department for respond number 1. R. Borua. H. Borua, Learned Counsel representing Mr. B. Gugoi, Learned Standing as a Finance for the respond number 2. MSM Bormon, Junior Government Advocate Assam for the respond number 3, 4, and 5. Full stop. It is the case of the petitioner that the petitioner's son died due to injuries sustained in a road traffic accident, occurred at a public place, on 7/10/2019. Full stop.
There's a pillion rider.
Huh?
Pillion rider.
Claiming ex gratia amount of rupees 2 lakh in terms of the notification dated 15/11/2014 of the Revenue and Disaster Management Department, the instant writ petition has been prepared. Issue notice returnable ago to kiman asil 8/12 as MS so and so appeared and accepted. No formal notice. Extra copies within 2 working days.
Item number 13 also similar.
One
13.
minute. Item number
13.
13. Sound 13. What is the relation?
No, this is a different Lordship.
Uh-huh.
There is also mother is claiming.
Petitioner's son, huh?
Son. Petitioner's son.
Date of accident?
16/6/2020.
Huh?
16/6/2020.
Yes, 16/6/2020. বাকিখিনি একেই রেসপন্ডেন্টেরা চাই ল'ব Respondent same,
Respondent same.
same J.
Item number 12.
Yes, Mr.
Yeah, Muslim Lordship. Yeah, Muslim Lordship.
M. Hussain, petitioner.
Lordship, here NOK is not annexed. Next of kin certificate is not
Ah.
annexed.
N. Boduloi, revenue 1. H. Borua, Agonisna 2. M. Bormon 345. Petitioner son. Accident date 30/12/2018. The learned counsel for the respondents have submitted that. Submitted that the petitioner has not brought the next of kin certificate on record. Post of the petitioner. Therefore, the petitioner may be directed to bring the NOK certificate on record. Post of issue notice extra copies 2 days. The petitioner may file additional affidavit to bring the NOK certificate on record on or before the returnable date.
Lordship, for item number 15, Lordship. Similar matter.
So,
15.
NOK. NOK.
No.
Lordship, NOK is there.
Objection.
There. NOK is next to.
NOK is there. Okay. Petitioner son.
Yes, Lordship.
Accident 13/5/2021. N. Boduloi 1. H. Borua 2. M. Bormon 3, 4, and 5. Extra copies 2 of it.
Lordship,
NOK nalage.
NOK is not annexed.
NOK is not an X.
Not an X.
Same. Same date.
Item number 14.
NOK.
NOK is there.
Akan.
Yes, Lordship. All record is available.
Petitioners.
Petitioner number 1 is the wife and 2 and
N. Boduloi 1. H. Borua 2. M. Bormon 3, 4, and 5. Relation.
petitioner number 1 is the wife and 2 and 3 is the daughter.
Okay. The petitioner's
Next,
husband, stroke father. Accident date
25/12/2022.
25/12/2022. NOK nalage. Ase. Issue notice returnable on 8/12. As so and so appeared, accepted. No formal notice. Extra copies 2 working days.
16.
Obliged.
M. Hussain.
Son of the petitioner died on 27.
N. Boduloi 1. H. Borua 2. M. Bormon 3, 4, 5, 6.
Here NOK is not annexed.
Annex.
Not annexed.
Okay.
Extra.
28.
It's annexed.
Annex.
Page 28.
Page
Okay.
28.
Petitioner's son.
Yes, my lord.
Date of accident 27/2/2023. NOK nalage. NOK part 2. Returnable 8/12. Appeared, accepted. Extra copies 2 working days.
But item 26 also similar.
26.
Here husband died, my lord, or accident.
M. Hussain. NOK.
NOK is there, my lord.
NOK is there.
Page 25.
নাম কেটা লিখি দিব N. Boduloi 1, H. Borua 2, representing B. Borua. M. Bormon 3, 4, 5, and 6. Petitioner's husband.
Yes, my
Accident 3/1/2023. returnable 8/12/2023, extra copies 2 working days. Obliged.
I'm obliged.
Item number 17.
There is no representation on behalf of the petitioner today on call. MS S. Sharma. Learn it. Junior Government Advocate Assam for the respondent number 2, 1, 2, and 3 is present. There is an order of the Supreme Court, I think district commission, deputy district magistrate should take prompt action.
For possession, I'll.
Should pass an order for possession. There is Supreme Court judgment. As we have non-representation on behalf of the petitioner today on call is the case. In the next week, on the date to be fixed by the office.
Item number 18.
Here, Margot, the two is now. Oh,
Looks. It's a very.
you're okay. We are into 18 now.
In 17, if your lordship may kindly take up.
We'll take up.
Lordship.
We'll take up later on. There is no representation. 18. On behalf of the petitioners, what is the case?
Lordship, this is land acquisition compensation. Money has not been released by the Water Resource Department yet. That is a grievance of the petitioner, Lordship, page 13.
Enhanced compensation judgment and order.
Yeah, sorry, your lordship.
Additional
Lordship.
district magistrate. Mr. Mozumdar.
Yes.
If it is a judgment,
An
an order of additional district magistrate,
Yeah,
huh?
yeah.
Then what is the remedy?
Remedy, your lordship, already.
Remedy that High Court should be the executing court.
No, I already.
We'll go on executing every
No,
court's,
I,
tribunal's order.
no, I am not on that, your lordship.
That is what.
After obtaining the judgment,
Immediately release and make payment of the enhanced compensation to the petitioner as awarded by judgment and order dated so and so.
yes.
Reference court order.
Yes, after
Right.
reference court order, your lordship, I submitted before the deputy commissioner who is the disbursing.
Now tell me,
So the
reference court under Land Acquisition Act
yes,
or the new act, regular act?
it is under
1894? Where is the judgment?
yes, it is under 1894.
So,
Judgment 1894.
matter was referred for enhanced compensation.
Yes,
The reference court passed the judgment,
enhancing.
enhancing compensation.
Yes.
Now, what will be the recourse?
Now the
Now,
deputy
what should be the recourse? Tell me.
here
Tell me under the law.
under the execution.
No, 1894. So, execution or a writ petition?
Execution is because it is not a suit, your lordship. It is a reference case, your lordship.
A reference case. But whether that court has power or not.
No, reference case, deputy commissioner, it is a direction for
Huh?
directing the deputy commissioner.
Section
your
18, let us see. I know, don't know.
lordship.
I don't know.
Let the notice may go, your lordship.
No, will not, if efficacious remedy is available, why should we issue notice?
Yes.
Absolutely, we are not in
Because
favor of that, if it is not.
reference case, your lordship, there is no provision for execution, your lordship.
Is it the decree or what?
Decree, your lordship.
Have you submitted with responsibility that all the responsibility?
After
18,
judgment,
19,
after judgment, I am.
in making the reference,
after judgment, I am-
service of notice, restriction proceedings shall take place in open court. Yes, any of the council? Should I look into the provision myself or are you going to submit anything? Ah, page 26. Page 26. Oh, sorry, section 26. Every such award shall be deemed to be a decree.
Yes.
And a statement of the grounds of every such award, a judgment within the meaning of section 2, clause 2 and section 2, clause 9, respectively of the Code of Civil Procedure 1908. In that case, whether executing court is the High Court under 226,
Hmm.
then 26 subsection 2,
Subsection 2.
1894. Why I should not dismiss your writ petition?
Let us go through the provision, Your Lordship. Let it come after day after tomorrow, Your Lordship.
Because it is a decree and judgment. If it is a
That
decree
is
and
so,
judgment
then-
under the
Yes.
provisions of CPC,
So if that is so, then execution will.
execution is to be done by the district judge itself.
Yes.
As a reference court, he has the power to don't relegate,
Your Lordship is correct.
don't relegate the High Court to an
Lordship-
executing court.
I was under the impression that it was not a decree.
That should exercise should have been done in your chamber
Yes.
before preparing the writ petition. Don't waste judicial time.
Let it come, sorry, let it come after day after.
Yes, MS Sharma, please note it down, section 26(2). Why we should waste such time? On the prayer of Mr. R. Mojumdar, Learned Counsel for the petitioner, list the case on Wednesday. Come up with some Supreme Court judgment
Yes, yes.
that yes, 26(2) is not applicable in your case.
Obliged.
Yes, Mati. কিমান আছে আমি কিমান হলো আৰু কন্টিনিউ যাম তাৰপিছত মাতি
Number 19.
I'm obliged.
Chief, in this matter, actually, the subsistence allowance which I have to get actually at the time of my imprisonment, it was a civil one actually. I had, it was not given actually. So I am praying that the
matter is regarding the City Cooperative Bank.
City Cooperative Bank.
Release the case before any other events without me.
Yes, my lord.
Other events, not before me.
Item 20.
May I please, Your Lordship? In this case,
Mr. W. Rahman.
Yes, my lord.
MS PR Mohanto,
My lord.
Revenue 1. H. Borua, presenting to B. Gogoi, 2. S. Sharma, Junior Government Advocate of Assam, 3, 4, and 5. And okay?
Yes. I have an.
And next? Okay. Petitioner's husband. Accident 27/4/2018. Issue notice returnable 8/12 as so and so appeared, accepted. No formal notice, extra copy, you need to open it.
I think 22 also similar. 22.
2020.
Here in this case, my lord, the brother of the petitioner, my lord.
Respondent same.
Yes, my lord.
Respondent
Again,
same. Respondent same. Petitioner's brother. Accident date 8/5/2022. Extra copies 2 of this. Returnable same 8/12.
I think 25, man.
25.
Right.
W. Roman, Monto 1, Borua 2, Sharma 3, 4, and 5. Petitioner's husband, date 8/10/2015. Issue notice returnable difference.
All right.
Item 21.
Okay, that other one also is
No, it's a similar
used.
issue, my lord.
Okay, 17.
Similar issue, my lords, applications under section 14 of the Surface Act are for physical possession. In item 21, my lords, it is the Deputy Commissioner Kamrup Metro. And in item 17, my lords, it is the Deputy Commissioner of Kachha. That is
What to
the-
do at this stage?
My lord, if they can take instructions that they are willing to set a date for physical, because it's a very simple, my lord, ministerial act, my lord, nothing much to determine as such.
And this act is,
Section 14 of the Surface Act. If they can take instructions, my lord, then it can be discussed.
if they are the only party, then we can issue notice, short notice.
I have made
10 days.
I have made the private respondents a party, but perhaps it can be because, my lord, the Supreme Court has held in several judgments that
Any order? Show me some order.
but there are orders, but let them take instruction. I will place the order before your lordship.
Okay, heard Mr. A. Ganguly, learned counsel for the petitioner. Bank. And MS S. Sharma,
1, 2, and 3.
learned junior government advocate Assam, correspondent number.
1, 2, and 3.
Item 21 of, 1, 2, and 3. MS Sharma, learned State Council has sought for listing of the case on
Next week, my lord, Monday, subject to the convenience.
Monday. Everybody will be enjoying Diwali.
Wednesday, in that case.
Wednesday or Friday, take it Friday. In order to enable her to obtain instructions in a matter. Place the case accordingly on such. Same in item
My lord, item 17.
17. MS Sharma, you are for
1, 2, and 3. My lord.
120. A. Ganguly, petitioner bank. R.S. Sharma, 123. Same order. Friday.
Even the item number 19, the C property bank, there was also another department, the Bakida department. So I think this bank has the power to.
No, this is not by me. This case is not specifically by me, not by the court, not by M. Chaudhary, comma J. Understood?
Little bit minor, that's another this candidate.
Understood?
Now, thank you.
Owner of a plot of land measuring 21 acres. My lord, that land was taken by the government under the Chilling Act. Subsequently, it came to the notice of the government that it has been wrongly acquired. Lordship, may turn to page 19, Annex 1, my lord. This is a communication, my lord, issued on 17th of March 2005 by the Deputy Commissioner to the Commissioner and Secretary to the Government of Assam, the Revenue Reforms Department. May I read, my lord? Subject review of the order of the District Collector in sealing case number so-and-so for restoration of Patta land in the name of Sri Asghar Ali. Asghar Ali is my lord, the father of the petitioners before your lordship. In inviting a reference to the subject cited above, I have the honor to inform you that the area of land measuring so-and-so covered by Doug number 48 and 177 of Khatian number 48 of village supply part 2 under Rangjuli circle, erstwhile Dugnoi circle, being the joint patta land of one Mrs. Monima Nessa, wife of so-and-so, and Sri Asghar Ali, son of so-and-so, was shown to be a sealing surplus land in sealing case number so-and-so, and acquired by the government accordingly during the year 1976. But prior to the acquisition of land, an area of land measuring 10 Vika 3 Katha 0 Lesa, covered by Dag number 177 of Khatriyan number 48, jointly held by both the Pattadars, was sold by the co-Pattadar Srimati Moinan Nessa. The rest of the land was allotted to 7 numbers of landless persons during the same year, but only on 24/2002. But the physical possession of the land was delivered to the allottees only on 24/2002 by evicting the original Pattadars, Mrs. Moiman Nessa and Azhar Ali. Out of the aforesaid 42 bighas 4 Katha 0 Lesas of land, the extent share and interest held by Sri Asghar Ali was 21 bigha 2 Katha 0 Lesa, and the quantum of land held by him should not have been included in the ceiling case. In a clandestine manner, the land extent exclusively belonging to Asghar Ali was also included in the return submitted by Sri Rustam Ali Sarkar and wrongly shown as ceiling surplus land under section 7(1). The land was thus acquired wrongly as ceiling surplus land and distributed to landless person. As a consequence, Sri Asghar Ali became landless person since the acquisition of the ceiling surplus land, being part of the joint patta number 48. Being aggrieved, Sri Asghar Ali approached to the Deputy Commissioner Gwalpara via his prayer dated so and so, praying for restoration of his patta land by rectifying the error in the relevant records. The matter was inquired, this is important, my lord. The matter was inquired into by the Assistant Settlement Officer, Dudhnoi Circle. The report submitted by the Assistant Settlement Officer, Dudhnoi Circle, revealed that the portion of land measuring 21 bigha 2 Katha 0 Lesa, covered by Dag number so of village supply part 2, belonging to Asghar Ali, has been wrongly shown as ceiling surplus land in the return under section 7(1) by the returnee and acquired as ceiling surplus land and distributed to the landless persons. On scrutiny of the report submitted by the Assistant Settlement Officer Dudhnoi, along with the relevant papers and documents pertaining to the land, and in view of what has been stated above, it can be suggested that if the allottees of the aforesaid portion of land of patta land acquired ceiling surplus land can be accommodated in some other areas of government khas land, then the land as prayed for by the applicant can be resorted in the name of Asghar Ali. Hence, I would request you kindly to arrange to review the order of the collector of Gwalpara passed on so in ceiling case number so and communicated necessary order for taking lawful steps for restoration of the patta land of Asghar Ali. It was issued by the Deputy Commissioner to the government, my lord. Subsequently, my lord, Lordship here turned to the next page. Government granted approval also, my lord. This is the type copy, my lord. Lordship has got it, page 21. It is dated, my lord, 23rd of October 2008. From the Joint Secretary to the Government of Assam Revenue and Disaster Management Department to the Deputy Commissioner and Collector Land Reform Fund. My lord, reference, my lord, Lordship is the same letter I have shown to your Lordship, my lord. With reference to the above quoted subject, I am directed to convey the approval of the government for restoration of patta land measuring an area of so covered by Dag number 48 and 177 of Khatriyan number 48 of village supply part 2 under Rangzuli Circle in favor of Asghar Ali, son of late Kundu Sheikh of Dudhnoi. The land was made ceiling khas land in ceiling case number so wrongly and inadvertently. Necessary land records may be corrected accordingly. Allotment certificate, if any, issued in this land may also be cancelled. This was issued, my lord, on 23rd of October 2008. Then if your lordship turns to the next page, my lord. Page 24, my lord. A direction was issued to the circle officer to implement that order. That your lordship will find at page 24.
Yes, Mr. Sharma.
Obtain instruction.
And in fact,
Mr. T. Chakraborty, Learned Counsel for the petitioners. MS P.S. P.R. Mohanto, Standing Counsel, Revenue Department for the Respondent number 1 and 2, and MS S. Sharma,
3 and 4.
Junior Government Advocate Assam, for respondent number 3 and 4. Full stop. The petitioners, comma, 4 in number, comma, have claimed that they are successors in interest of one late Ajgar AZZAR Ali, son of late Kundu Sheikh. Full stop. The petitioners have referred to a letter dated 23/10/2008, annexer 2 within bracket of the government in the Revenue and Disaster Management Department, whereby the state government had accorded approval for restoration of patta land measuring 21 bighas 2 kathas, comma, covered by dag number 48 and 177 of Khotian number 48, comma, situate in village supply part 2 under Rongzuli Revenue Circle in favor of Asghar Ali, comma, who expired on
In the year 2010, my lord.
who expired in the year 2003.
10, my lord.
10.
10.
Full stop. The petitioners have also referred to a report of the Deputy Commissioner Gwalpara dated 17/3/2005, wherein after inquiry, comma, it has been reported that the subject land should not have been included in the proceedings of sealing case number 114/ZC/D/75 within bracket State versus Rustom Ali Sarkar, bracket close, in the year 1976. Full stop. It has been further reported that the subject land was included in the return wrongly, showing the same as sealing surplus land under section 7 within bracket 1 of the what is the act?
Assam Fixation of Ceiling on Landholding Act.
Assam Fixation of Ceiling on Landholdings Act 1956. And as a result, comma, the land stood acquired wrongly and consequently distributed to landless person. Full stop. The government in the Revenue and Revenue Department in the letter dated 23/10/2008 had directed the Deputy Commissioner Gwalpara to correct the land records and to cancel the allotment certificates, comma, if any, issued in respect of the subject land. Full stop. Alleging inaction on the part of the respondent authorities, despite submission of several representations by the petitioners, comma, the petitioner has preferred the instant petition, issue notice returnable in 4 weeks as so and so appeared, accepted, no formal notice, extra copy in two working days. The petitioner shall take steps for service of notice upon the respondent number 5 to 17 by registered post with AD within 2 working days from today. The respondents shall file responses in the meantime.
Meanwhile, they may be set at liberty to approach the deputy commissioner. Nowhere in the documents annexed to the writ petition, it is my duty to place before this honorable court. How the petitioner is linked to Asghar Ali? Well, no document evidencing in all the representations.
Well, fact finding can be done by the deputy commissioner. There is no issue.
Okay, now you file them, you file the response.
I will.
Item number 27.
We have proceeded. My lord, here in this case, my lord, petitioner's license, fair pay shoot was license suspended, my lord.
License.
Yes, my lord. Suspended, page 31, your lordship may found it.
This comes from. This is under Essential Commodities Act.
Yes, my lord, 15/6/2023, my lord.
It will be bench four.
Bench four, madam.
Mr. I Alom.
My lord.
And Mr. Yes, Mr. This is Essential Commodities Act.
Lordship, the bench four matter. My lord,
Mr. J. Henry. Learned Counsel for the
license
petition.
suspended on 15/6/2023, my lord.
Right, this is not the roster. And Mr. J. Henry, Learned State Counsel for the respondents have submitted that the petition pertains to an order passed under the Assam Public Distribution Articles Order 1982.
82, my lord.
82. 82,
82.
comma, an order, O capital. Framed under the Essential Commodities Act 1955. 55?
My lord.
55, oh, sorry. Full stop. They have thus submitted that the subject matter of the petition pertains to full stop. The registry to verify and release the case accordingly before the appropriate lens.
Item number 31.
My lord, this matter issues eviction from the land. I have been residing within the territory of Nagaon district, my lord. And the Karbi Anglong district, along with the borderline of Karbi Anglong district and Nagaon district, my lord. I have been paying regular revenue at page 32, my Nokoteria under Puja subdivision, my. And
Nokuti nonke.
Nonke, my lord.
Bedokoli Jorimona.
Yes, my lord. This land belongs to the state government, but we have been occupying that land and since long back, my lord. And but the Karbi Anglong authority, my lord. Karbi Anglong authority by serve notice earlier, my lord. The borderline dispute is not settled by the government of Assam, my lord, till date. But on but earlier, my lord, the Karbi Anglong authority, by enforcing the area of Nagaon district, evicted some of the inhabitant villages from that land, my lord. In that event, my lord, some occupier, the villagers, approached this honorable court, and this honorable court This honorable court, at page 67, by the order dated 8/3/2019, granted interim matter. 67, my lord. Relevant person at 68, my lord.
Yes.
And thereafter, my lord, the government initiated a process to settle those land with the villagers, my lord. Thereafter, we have withdrawn this case at page 69, my lord. Relevant person 17. Taken from my lord. Inamuddin Honor Counsel for the petition has submitted the petition. The petitioners do not want to pursue this petition as they want to approach the appropriate authority individually seeking settlement allotment of land under existing land policy 2019 and prevailing law. And this was with liberty was. Thereafter, my lord, in the next day, my lord, on 27, next page, my lord, 71. This notice was issued by the Kabi Anglong authority. Which was received by 11/7/2022. And asking to villagers to vacate their lands. And thereafter, my lord, they evicted some of the petitioners' land, petitioners demolished some houses.
Petitioners have been evicted.
Not evicted, my lord. Some of them. Some of the.
These petitioners.
Yes.
These petitioners.
My lord, some land of the land of the petitioners and that the houses of the land are houses of the petitioners. Some were evicted and some were not evicted. And
These petitioners.
this petition one, and their land, cultivated land within their occupation, my lord. But now, thereafter, my lord, we have approached this honorable court at page 74, my lord.
Yes.
That relevant person started from that 79. It order dated 26/7/2020. Para 8. Para 7, my lord. 78 page. Was submitted on account of timely intervention of the Hudai district administration, petitioner have not been evicted, taking into account that the land they are possessing falls within the Nagaon district. Next, my lord, 8. The issue therefore arises herein as to whether respondent number 6 and 8 would have the jurisdiction of eviction in respect of area which falls within the jurisdiction of Hudai district administration. That Kabi Anglong district autonomy. They evicted us. Taking into account of the
So these petitioners approached or what? Who are the petitioners there in this case?
Yeah, another set of another villagers. From same village.
Same village.
Same village. No, no. Same village, same area, my lord. There, now, my lord, after this order, the eviction process has been stopped by the Kabi Anglong authority. Discussion is going on, my lord. But the land of the petitioners and land of the petitioners which are not occupied by the Kabi Anglong Autonomous Authority, but they restrain us to harvest and to go for cultivation, my lord. Therefore, similar order is necessary, and direction may be granted to the Naga administration to protect our life. And we are unable to harvest our crops, my.
Yes, Mr. Pipia, what is this case?
My lord, Lordship, look into the, my lord, the page 32. The English translation, my lord. Page 32, no, my lord, page 34. They have annexed page 34. There's, next page, page 35 is a translation. There is nothing, my lord. From whom received, everything is blank, my lord. Page 34, my lord. For which year, date, from which received, name of village, pata number, revenue, everything is, my lord, blank. Then page 35, the name is that one name is there. There is no kuti, non K. That is a Bedokholkari Jorimana. Everything was missing, my lord. In the page 34. And they have, whether the petitioner have right over the land or not, my lord, it can be ascertained only on the basis of the documents furnished before this honorable court, my lord. If they have not furnished the documents, my lord, whether they are the encroachers or they are the patta holders, it cannot be ascertained, my lord. And whatever documents they annex, my lord, vernacular, all are the, my lord, they have annexed only for, my lord, document in respect of, my lord, 1 to 7 and 10, my lord. No other documents of the other petitioner have been annexed in the petition, my lord. Only they have annexed the document only in respect of the petition number 1, 2, 3, 4, 5, 7, and 10. And the no documents of the other petitioner have been annexed, my lord. And after, my lord, vacating the interim order by your lordship at page 70, eviction was carried out in the presence of the Director of Land Records of Assam, Pujai Administration. And 15 houses were not evicted, my lord. We have placed on that date also, my lord, a record. When the Honorable Court asks us to take the instruction, 15 houses we have not evicted due to the border dispute. Earlier, 7 lead petitioners approached this court, and the court passed an order that if they are, whether they are within that 15 houses or not. Now they are filing, my lord, 26 petitioners. Our earlier instruction we have produced, my lord. In that case, my lord, that page 71, where the Honorable Court passed an page 78, my lord, last paragraph, paragraph 6. Page 78, last paragraph. It was further mentioned during the eviction process in Lankajan in USF, 233 numbers were evicted corresponding to an area of land measuring so and so, whereby 1160 persons were displaced. In respect to Khurdesang USF, 14 houses evicted corresponding to so and so. It was further mentioned that 15 number houses were left at Ambari area due to border dispute, and the eviction in respect of the said houses would be carried out in consultation with the Pujai District Administration and the official of Director of Land Records in due time. The said instruction kept on record, my lord. In respect of the 15 houses, my lord, that has been protected, my lord. Now they are coming with the 26 persons without furnishing any documents, my lord, land documents. Paragraph 6, my lord. It has been clearly stated, my lord, The said eviction drive was carried out on so and so date after consultation of the Khuzai district administration and the official of the land survey. It was further mentioned that during the eviction process, so and so were evicted. And at that time, 15 houses and the petitioner earlier repetition, some of the 7 repetitioner approves, my lord. So the honorable court that they may be within the 15 houses, my lord, so the protection was granted. Now they filed without, my lord, enclosing any document. In respect of the paragraph petition number 11 to 26, they approach this court. And all the documents they have annexed it is also blank, my lord. Page 35, my lord. So, my lord, it is a defective application. And the application is first initially required to be cured, my lord. Then thereafter it can only be, my lord, entertained, my lord.
Some names are there.
No, page 34, no name is there, my lord. Cancellation.
Cancellation in a
Page 34.
vernacular.
Vernacular name is there. One name is Zahida Khatun. There is a petition number 1. Then, my lord, page 36, vernacular 2 persons are there. 3. Then the petition number, page 37, 4 persons are there. 7, 2, 3, 5, 5 plus 4, 9. All the petition 37, 38 is the same. And the page 40 is then another person, Mohammad Monas Ali.
40.
40.
40. 40.
Page 41, another person, Nizamuddin. Then thereafter, nothing, my lord. All the petitioners, my lord, if they are the occupier of the land, my lord, encroachers also, they have to make a statement that they are the resident of so-and-so village and they want require the protection.
Some of the, I have revenue receipt itself says that we are the resident of.
Right, but few.
Yes.
Few out of 26.
Yes,
How
my
many?
lord, I have annexed some of the revenue receipt, my lord, some
1,
of the
2,
revenue.
3, 4, 5, 6, 7.
No, you are coming up with a petition
For
to
26
secure your lands. You are coming up with.
But I have annexed some of
Because
the.
for that, some disputed questions of fact would call for consideration. Whatever the case may be.
My lord, I have stated in my petition some of the revenue record. Some of the revenue.
This Lankajan and Kludung. These are within Karbi Anglong district.
My lord. The, within the reserve forest, my lord, we are, my lord, evicted the persons who are residing in the reserve forest.
Not mine.
My lord, and they are submitting the document of the, my lord, Nofuti Non-Ke Duinong survey posti. So we are not concerned on that, my lord. We are concerned on our land, my lord, within the territorial jurisdiction of Karbi Anglong Autonomous Council, my lord. So if they, my lord, protection from the eviction from the reserve area, my lord, they have to show that they are the occupier of that area, my lord. And by annexing the, without annexing the documents, my lord, they are seeking the protection against, my lord.
So they are carrying out the eviction in Lanka, USF and Kludung. So what rights of yours have been violated?
My lord, I have stated in
were you among those 233?
My lord.
Are you among those 233 number of persons?
Yes, my lord.
Huh?
So not 33, my lord. So we are the villagers, my lord.
Oh.
Of that area, my lord.
Of that area will not do. Are you within this area?
Yes.
Lankajan USF and
Yes,
Kludung
my lord.
USF.
Nokuti, Nogajan area,
Huh?
my lord. It is a big village, my lord.
No, big village is different thing. This is, I think, forest.
Not forest land, my lord.
Forest.
Not forest land.
They
my
are
lord.
carrying out eviction in forest
My lord,
areas.
notification 1951 notification I have annexed, my lord.
They have that notification we have annexed in the earlier petition, my lord. Our affidavit, they have copied it and filed it along with us, my lord. On that we have in the earlier petition, we have taken the plea that that is the notification within that area we have the jurisdiction. Thereafter they withdraw the repetition. Then eviction was carried out. Then after eviction was carried out, at 15 houses were not evicted, they approached the High Court. High Court protected that those persons may be within that 15 houses. Now they came with that annexing that order that they are the 26 persons again, without annexing any document that they are resident of that particular area.
So if they are residents of Hojai,
yes,
suppose they claim, Now you carry out this eviction within the
Lord,
areas of
Yes,
Longkaijan,
sir. My lord,
USF and Karbi Anglong.
Now, there is nothing, we have not taken any steps for eviction, my lord, at this moment, my lord. Eviction has already been carried out. Now they want to protection of this court so that they can go and harvest the land, my lord, within our area. That is the, my lord, things now going on, my lord. That cannot be, my lord. That at this moment, my lord, there is no, my lord, eviction drive, my lord. Eviction has already been carried out.
If you are not residents of
Karbi Anglong, my lord.
Karbi Anglong,
I'm not
there is no question of
My lord,
giving you protection.
Lordship is looking at the prayer, my lord.
Yes, I am not.
Case 20.
You are alleging action on the part of the Karbi Anglong authorities. Right.
My lord, they are prayer, my lord, page 28. They want the protection from district administration Nagaon so that they can harvest the land, my lord. If they are occupying the Karbi Anglong district, my lord, within the autonomous council, my lord. how
You
they can-
seek for protection from the Deputy Commissioner.
Deputy Commissioner, yes, my lord.
We are not here. First, you have to approach.
Admittedly, we are,
We can only submit that statement of Mr. Sutia that they will confine the eviction drive within the areas of Karbi Anglong Autonomous Council, including Lankaijan, USF and Kludung.
my lord,
That much we can do.
my lord,
We can only record that statement.
my lord, my
We
lord,
will not go into
My
the
lord-
bona fide of the petitioners. If they are of the Hosai district, you approach the Hosai district administration.
so we have
They are
already,
not touching. They are not touching you.
at the intervention of the Huzai district administration, the eviction process was stopped.
So you have been protected.
No, my
by
lord,
the
some of
Hosai
the,
district
they have
administration.
evicted us. Some, they
Don't try to
only-
get something in an indirect manner.
My lord,
Come to the direct point. If you are not being disturbed by the Karbi Anglong Autonomous Council, end of the matter. We can only observe that Karbi Anglong Autonomous Council shall not take any action in respect of residents of Hosai district administration.
and their property, my lord, their cultivated land.
We don't know about that. We don't know about properties.
Protection.
They should confine their action within the areas of Karbi Anglong Autonomous District Council areas, including Lankaijan and so and so. And they shall not take any action in respect of disputed areas of land and land belonging to Hosai district administration. We can only observe that much.
My lord,
We can only observe that much. Otherwise, we will be issuing
one
notice.
fact is that,
Hard, Mr. A.K. Doctor.
my lord,
You're not being
similar
able to
order may be
make out the
passed.
privacy case, Mr. Doctor?
Similar order may be passed, my
No
lord.
similar order.
My lord, protection may be granted, my lord.
No, that
Because-
is what,
Earlier, we could not,
that is what I have observed, Mr. Doctor.
But how
that-
can they impose the other district, my lord?
Paragraph 9 I am observing.
Paragraph 9 of
That order, same order,
paragraph 9.
only that Karbi Anglong Autonomous Council area shall not carry out any eviction proceedings in the areas falling within the district, Hosai district administration. That is what,
That is,
I am only observing that only. I have already indicated to you.
and take necessary.
Oh, that's I do not know. For harvesting, you go to the deputy commission. For eviction purpose, if you are in the Hosai district administration, you will be protected by this
Yes.
paragraph 9
Yes.
observation. If you are into the jungle, then Mr. Sutia will protect you if necessary.
The administration has
Oh.
initiative, my lord, already.
Firstly, you are an encroacher paying Bedokoli Jorimana. You are not sure whether you are encroaching Karbi Anglong or Hosai or Nogao, right?
No, my lord.
So our observation is only limited to you are apprehending action against whom? By Karbi Anglong Autonomous Council. So they can carry out eviction exercise in respect of forest areas. What right you have? What right you have so far that forest area is concerned?
Forest area, we are
Then-
not occupying, not occupying.
Then,
We are not occupying, but government land is occupying.
so
not forest land.
They will carry out the eviction exercise only in respect of the Karbi Anglong Autonomous Council areas. They should confine their action.
My lord, 1958.
Have you understood what I have said?
This is a half shackle area, my lord. They want to, this is the half shackle area, my lord. As per the 1958.
Hojai District Administration and Karbi Anglong Autonomous Council Administration, they are in the best position to know what is their exact boundary.
Yes, ma'am.
Right?
Yes.
We sitting here cannot ascertain that. Right?
Yes, sir.
Now, if you are apprehending any action from the KAAC authorities, we can only observe that KAAC authorities shall confine any exercise within the areas of the KAAC.
Yes.
Or, to make it very simpler, that they suppose you are in India, then Pakistan will not come into your area. That is what the court is observing. That's all. We don't know about how much land you are occupying, where you are occupying. But only thing is that KAC shall not cross over.
Yes, my lord.
That is what.
Cross over their boundary.
That is what we are observing. Heard, Mr. A.K. Dutta, Learned Counsel for the petitioners. Mr. Shutia, you appear for?
I am appearing for my lord. 6,
And
8, 6 and 8, my lord only.
Hendik?
One,
Two,
three, well, local revenue, I can also know that. 2, 3, 4, 5.
1, 2, 3, 4, 5.
4, 5, 7,
7, 9.
9.
Heard, Mr. and J. Hendik, Learned Junior Government Advocate Assam for the respond number 1. 2 also? Or 2 revenue? 1.
No, 2.
DLR? Okay. 1, 4, 5, 7, and 9.
7 and 9.
MS PR Mohanto, Standing Council, Revenue Department for the respond number 2 and 3. And Mr. J. Sutia, Standing Council,
6 and 8.
Karbi Anglong Autonomous Council for the respond number 6 and 8. Full stop. The petitioners, 26 in number, are claiming to be residents of the village number 1, Sarke Bosti, and village number 2, Sarke Bosti, within the territorial jurisdiction of District Hojai. Full stop. The petitioners are apprehending that the Karbi Anglong Autonomous Council authorities, respondent authorities, had undertaken an eviction exercise on 11/7/2023 in the areas under Longkajan USF and Ludung USF under Karbi Anglong West Forest Division. Full stop. The petitioners are apprehending that in the plea of evicting, on the premise of evicting unauthorized occupants from the areas falling within the Karbi Anglong Autonomous Council area as including Lonkajan USF and Kludung USF, comma, they might be evicted from the lands they are presently in possession. Full stop. The specific case of the petitioner is that the lands they are possessing fall within the jurisdiction of Hojai district. And as such, the Karbi Anglong Autonomous Council authorities are not authorized to undertake any eviction proceedings. In respect of the plots of lands, the petitioners are claimed to be under possession. Full stop. Mr. Chutial and Standing Council KAAC has submitted that when the eviction drive was carried out on 11/7/2023, the same was with consultation with the Hojai District Administration and the officials of the Directorate of Land Records. Full stop. He has further contended that the eviction process was carried out in only Lonkajan USF and Kludung USF areas. Full stop. As there was some dispute as regards 15 number of houses, comma,
At Ambari area.
in an area called Ambari, due to border dispute between the KAAC and the Hojai District Administration, comma, those 15 number of houses were not taken under the purview of the eviction exercise. Full stop. Where the matter would require further examination, issue notice, returnable in 4 weeks. As so and so appeared, accepted, no formal notice, extra copies within 2 working days. Having regard to the projections made by the Learned Counsel for the parties, comma, this court is of the considered view that till the returnable date, comma, the interest of justice will be made to direct the parties till the returnable date, the respondents, the respondent KAC authorities shall not undertake any eviction process in the areas falling within this Hojai district, Hojai district, and in the event of any dispute, comma, such exercise should be undertaken jointly in consultation with the Hojai District Administration and other stakeholders.
Item number 32.
May I please, your lordship? My lord, this writ petition was filed apprehending eviction from a plot of land situated in Davaka Revenue Circle. And earlier, my lord, 15% approached this honorable court in respect of the same issue. And that case has been closed after this honorable court asked the authorities to get the instruction whether they are taking up the drive of eviction or not. So the government advocate produced the letter before this honorable court where the government authority has said they are not planning to go for any eviction drive. So as such, this petition was closed with a rider that as and when such things.
Who is that order?
My lord, this order is writ petition number 5895 and 1610/2023.
Yes, apparently Vizier land.
Yes.
Ah.
Uh,
So you are occupying Vizier land.
yes, my lord.
Ah. And
Only our apprehension that without issuing any notice and these people are landless people. So according to the letter which was produced before this honorable court, dated 15/10. So they
so
said,
at that time, no eviction was contemplated.
Yes.
Right? Now what is the situation?
Still, same.
Same. Then?
My lord, with this observation, this petition can be closed. With this observation, this petition can be closed.
What?
As and when similar order, my lord.
Lordship is a premature matter, Lordship.
Huh?
How can my lord, they can approach my lord that Lordship was given the direction, my lord, not to evict or not to, my lord, consider. They are already, my lord, occupied a government land, my lord. Then no process has been taken, my till that, my lord, without, my lord, taking
What
any
kind of
process, my lord,
apprehension?
My lord,
Where is that apprehension? What have you stated here? There are 16.
Yes, my lord, that is one part. And another part is, my lord, when they came and measured the land and the officials said that they will evict all the people over there. My lord, as your lordship may be aware, my lord, after this delimitation, all the constituencies other than the district, all the remaining constituencies are made sub-districts. So they are going to have mini DC office in all the constituencies. For that, they are looking for a land. Incidentally, in this land, my lord, where we are residing, they went, the officials from the Dabaka Revenue Circle, they went and measured the land. They found around 25 bighas empty land. But while returning, they informed the people that they are going for a eviction drive in respect of that people who are residing.
Some tangible thing. Some tangible thing, yes, there some government record, yes. Something is contemplated.
Contemplated, yes, my lord. That was I said. That
some tangible thing, reliable source, contemplating to initiate, have not served any notice.
My lord, it's happening. Even without issuing the notice, the eviction is carried out. So that is for that fear we approach this honorable court. When this honorable court asked the authorities to find out if they are going for a drive, then only on 15/10/2023, they issued a letter and that was produced before this honorable court. So this honorable court, after going through the letter, informed us, my lord, that the department is not going for any.
Okay, we will be issuing notice. Therefore, you place your instruction, obtain your instruction, what to do. Heard Mr. J. Abedin.
My lord, if your lordship
we kept open for consideration.
Yes, my lord, if your my lord, next week if they get the instruction, my lord, the petition can be closed. If they are not going for a drive, the petition.
It is a government land, Lordship. At any time, my lord, when government is required, my lord, we can going for a eviction.
This is Vizier land.
Vizier land, Lordship.
Not only government land, khas land. This is Vizier land.
They are occupied.
You know about Vizier land, right from Jokpal. There is no requirement of also notice, but still we.
But my lord, in that letter which has been a correspondent to this honorable court, it is already said in this letter that various institutions are there. The character of Vizier is no more over there. And in that land, if they are going to have
in a land record, it is there or not?
My lord,
in the land records, it is Vizier or not?
My lord, yes, it's Vizier.
It is still Vizier.
Vizier. The character of Vizier is no more.
How can you say that?
My lord, if they are going to build the DC office, mini DC office over there, then where is
there has to be a procedure.
And my lord,
procedure for de-reservation.
My lord, yes, my lord.
Vizier can be made.
I understand.
Government land for occupation.
My lord, in my synopsis, if your lordship looks at the first page,
we'll issue notice at this stage. Heard Mr. J. Abedin, learned counsel for the petitioners, and Mr.
And for Lordship, respond number 2 and 3.
Okay. P.R. Mohanto, learned standing counsel revenue for the respond number 1, and Mr. J. Hendrik, learned junior government advocate Assam for the respond number 2 and 3. Full stop. The petitioners, comma, 2016 number, comma, have stated that they are living, they are residing in plots of land covered by DAG number 157 of Daboka Town Kisam, comma, known as Sutargaon Reserve, comma, under Jamuna Mukh Mauja since long. Full stop. The DAG number 157 consists of about 142 bighas of land. Full stop. The petitioners have approached this court by the writ petition on the apprehension that a move is afoot, A-F-O-O-T, on the part of the district administration by removal of foot for eviction.
Yes, ma'am.
For eviction of the petitioners from the said parcels of land ground on the premise of construction.
Yes, construction.
Construction of an office.
Mini DC office.
Of an office of the district administration. Issue notice returnable on so and so date.
Would your lordship be pleased to mention this case, earlier case?
Mr. Abedin.
Same area.
Learned counsel for the petitioners have submitted that on an earlier occasion, comma,
15 numbers.
15 number of persons, petitioners, comma, similarly situated like the petitioners in the instant case, comma, had approached this court apprehending eviction and in the said petition, comma, WBC number 5895/2023, comma, the Adani State Council, after obtaining instructions, had submitted that on 16/10/2023 that no eviction drive was contemplated for eviction of occupants occupying areas under DAG number 157. On the basis of the said instruction, comma, the writ petition was closed on 16/10 by an order dated 16/10/2023. Issue notice returnable on 11/12 as so and so has appeared accepted for all the respondents. No formal notice, extra copy during 3 working days. Mr. Hendrik, United States Council shall obtain instruction as regards any steps taken or contemplated to be taken in respect of DAG number 157 Supra on the returnable date. Will be at liberty to file if something is on.
Yes, deeply obliged.
Item number 33.
May it please your lordship.
Yes.
Lordship, this is a case where the petitioner had filed a right to information application dated 17/2/23 before the district circle officer. And thereafter, he didn't receive any information from the district circle officer. So he approached the first appeal authority, that is the deputy commissioner. And thereby after that, he didn't receive any communication from the deputy commissioner as well. So he approached the second, for the second appeal under right to information, that is the chief information commissioner. But meanwhile, on 17/7/2023, he had received the call for hearing on his appeal with the deputy commissioner. He went for a hearing, and on 17/7/2023, the deputy commissioner had given an order to the Dispur circle officer to provide and furnish the documents that he sought in his original RTA application dated 17/2/2023. That was within 7 working days. But the Dispur circle officer, thereafter, he communicated to the petitioner that the information that was sought regarding the parental property of the petitioner himself is lost, either lost or misplaced due to artificial flood. And as such, the information will be provided to him as and when it is available. So that is the entire reason why the petitioner has approached, because there is no time bound or time limit that has been provided by the Dispur commissioner within which he is going to provide the information. That is the entire case.
Where is that?
Lordship, page 28 is the Annex 1. That is the.
Where is the circle officer's observation?
That is in page 52, Your Lordship, is the translated copy, Your Lordship. 51 is the original copy that was received by the petitioner. It's in clause 3, Your Lordship, page 52. The petitioner, after receiving this letter dated 25/7/23, had also submitted a representation dated 7/8/2023, Your Lordship.
Hard, Mr.
D. Dekar, Your Lordship.
D. Dekar, Learned Counsel for the petition. Mr. J. Henry, Union Government Advocate Assam, for all the respondents.
Lord.
The petitioner sought. What is your RTI application? Where is
It's
that?
on page 28, Your Lordship, Annex 1.
Information and documents under the provisions of the Right to Information Act 2005. Full stop. From the office of the circle officer.
Dispute circle officer.
Circle officer, dispute revenue circle. On 17/2/2023. Full stop. The petitioner had to approach the first appellate authority as well as the second appellate authority. Thereafter, to seek to obtain the information and documents. Full stop. The circle office, Dispute Revenue Circle, had made a communication to the petitioner on 25/7/2023. Whereby the petitioner has been informed that the relevant records which the petitioner has sought, could not be found due to relocation of the circle office in the year 2015-2016 and due to artificial floods in the office premises or the office premises on several occasions. Full stop. The petitioner is aggrieved. No, full stop. Petitioner has been informed that the documents are being searched are being served. Full stop. The petitioner is aggrieved by the fact that the petitioner has not been informed any timeline by which he will be provided with the documents and information he has sought for under the Right to Information Act 2025. Issue notice returnable on so and so. Mr. So and so appeared, accepted, no formal notice, extra copy leading to Mr. Find out, reconstruct the records.
DPO by law.
11, 12, no? 11, 12.
Left out item number 23.
May it please your lordships. My lord, three petitioner before your lordships. Lordship, this petitioner have approached prior to 25/7/22 before the officer in charge
Dispose of
police station lordship. FIR, lordships, it was refused lordships. Thereafter, lordships, they have filed the FIR before the police commissioner Kamrup Metro lordships on 25/7/22 lordships. And time to time they have approached, but nothing is communicated to them lordships. And lordships, in the meanwhile, lordships, the factual case of this case is there was a forceful marriage between the petitioner number 1 and respondent number 4 lordships. And accordingly, lordships, when it could come to know that respondent number 4 lady, she is already married lordships.
Oh, those are things, married, unmarried, DV case is pending.
DV case is pending lordships. Now,
firstly, you are aggrieved by non-registration of your FIR.
Lordships.
Right.
Lordships.
Secondly, you are seeking passing of a DV case.
Lordships.
Right. For the first non-registration of the FIR, you have to approach under 156(3) CRPC. Law is very clear.
Lordship.
There cannot be any writ petition on that matter without approaching 156(3) jurisdictional magistrate. Secondly, this is not a writ petition criminal to quash a DV proceeding. This has to be registered as writ petition criminal or a petition under 482
now, lordships,
for quashing of DV.
Lordships.
Nowadays, writ petition for quash having criminal nature or within the province of criminal jurisdiction, I think writ petition is to be registered as writ petition criminal because law is clear. If it is writ petition criminal, then there cannot be any intra-court appeal. Next option is Supreme Court. Am I clear?
Lord.
So, if the FIR has not been registered by the by police, even after approach before the commissioner of police, then it is 156(3) CRPC.
Lord.
And second is quashing of DV proceeding, where you are claiming that this lady was married prior to the marriage with you. How can we decide all this? We are in 226. Mr. Sharma, you are a seasoned counsel. What to do? Will dismiss.
To withdraw the petition. To withdraw the petition, Lordship. I will withdraw the petition.
Both you have recourses separate recourses. For non-registration of the FIR, you go to Sakari Bosu, jurisdictional magistrate. He can direct the OC and commissioner to register the case and start investigation. Secondly, for diverse proceeding, where disputed questions of fact are involved or may not be disputed, that will be 482. Why 226? You pressing it?
Withdrawing lordships.
Mr. R. Sharma and Counsel for the petitioners, petitions has submitted that the petitioners want to withdraw the petition, in order to avail alternative remedy. Full stop. Mr. J. Henry Klein, Junior Government Advocate for the state, all the respondents.
1 to 3, Lord.
All or one for the
except for-
respondent number 1 to 3. Has no objection to the said prayer. Submission, full stop. In view of the above submission made by Mr. Sharma and Counsel for the petitioners, the petition is dismissed as not pressed, in order to for reserving the liberty to the petitioner to avail alternative remedy.
For admission item number 35 to 38.
Mr. Borhuya will take up on a hearing that to dispose of Thursday. Mrs. Mohanto, I have some basically today. Place the cases had Mr. J. Borhuya and Learned Counsel for the petitioner is in 1 to 3. Digital Borhuya and Mr. P. Mohanto, Learned Counsel for the petitioner in so and so. Are present, release the cases on Thursday as part of
Lordship, Thursday, I have on part of court number 1, my lord.
Huh?
On 9th, Lordship.
I have heard only to dictate.
My colleague.
I have been hard. You have been hard.
Yes.
Only I have some difficulty today.
My lord.
I also heard Mr. and MD Bora Lion State Council Transport. Please the cases on so and so as part of 9.
Interim order earlier, my lord, to be continued till then. Interim is there.
Interim is there.
My lord.
Not to settle.
Huh?
Not to settle till the returnable debt.
Nothing will happen till Thursday.
Only till March it is will continue.
Till Thursday, nothing will happen.
Item number 42.
Please, Your Lordship. Sometime maybe yes, sometime may be given to take instruction. Now I am able to contact the concerned person, my lord, Ministry of Education, my lord. So sometime may be given.
What is the case about?
Case is, my lord, regarding the compensation to the IIT. It is a matter of IIT, my lord. Rajiv.
Yes.
Petitioner is not.
Petitioner state.
Yes, state, my lord.
State of Assam is the petitioner.
Yes, my lord.
Okay. Yes.
Yes.
Surprisingly, the state of Assam is the petitioner. Yes. What is the case?
No, we are in a catch-22 like situation. Now, what is happened here, my lord?
Okay, instituting this
Count of
petition.
my lord acquiring land for the
Okay,
purpose
okay.
of.
I have recorded 1 minute.
Well,
Please respond number 6 and 7.
7 I am carrying, my lord.
7.
6
Who
and
is
7,
seven?
my lord, are the authorities of the Indian Institute of Technology, my lord. Respondent number 7. And R6, my lord,
7,
is
okay.
Union of India.
Payable to the degree holders in terms of common judgment passed by reference court in a number of reference proceedings. Yes.
My lord, few days back only I could contact that concerned person, my lord, so sometime maybe given I'll submit that instruction.
My lord, we are the decree holder, my lord.
Yes.
Actually,
You pursue the execution proceeding.
Lordship, the main problem is that once the WPC is pending here, the trial court has made the matter in captain abeyance. They are not proceeding with the execution.
We have not passed any interim
Yes,
order.
Lordship, that's right.
Law is also clear.
Yes, law is clear, but they have kept the matter is kept in abeyance, Lordship. So if
Our proposal petitioners. For the petitioners. You are appearing for whom?
my
All
lord,
the private respondents.
I am
it
for
is
the
a
private respondent 4 and 5,
Decree holders, my lord.
decree holder.
They are the landowners.
And who is for 1 to 3? Huh? 1 to 3. MS?
I am for 6.
SS? Bora, Learned Council for the respondent number 1 to 3. And Mr.
A Deka.
A Deka, Learned Council for the respondent number 4 and 5. And MS A Gayon, Learned Central Government Council for the respondent number 6. And Mr. A.B. Day, Learned Council for the respondent number 7. Mr. MS Gayon, Learned CGC, has submitted that she would need further in this time.
My lord, some long after, my lord, first week of December, my lord.
Okay,
Date may be fixed, Lord.
3 weeks time to obtain necessary instructions. First of, as paid for,
Okay.
and the prayer made by so and so is allowed. Raise the case on.
My lord, date may be fixed, Lord.
Okay, given?
6.
My lord, respondent number 7 has filed an affidavit, my lord. That has not come into record.
It will come.
Item number 43.
And so, like,
Lordship, matter has become infructuous. I may allow withdraw this petition.
Okay, MS
MS A. Hussain.
A
A. Hussain.
Hussain, Learned Counsel for the petition has submitted that the subject matter of the writ petition has become infructuous. Mr. J. Hendrick, Learned Training Government Advocate Assam, for all the respondents is in attendance. In view of the above submission made by MS Hussain, Learned Counsel for the petitioner, the writ petition is dismissed as infructuous.
44.
May I please, your lord. Well, I take your last order, my lord.
Lordship, I have received one step.
After a copy. And I order the order function. Keep it, your lord. Yes, my lord.
Roadside land.
But madam, we have been running we don't have any land for market, weekly market in the village, madam. We have approached to the Deputy Commissioner. We made a several repetition to the Deputy Minister also. Madam, they have forwarded everything, but there was a report was called for.
Now go through Assam Land and Revenue Regulation 1886 and settlement rules.
But that's
And roadside, if it is in the revenue record, if it is roadside land, if the land is reserved as roadside land, then that is not
madam, we shall give
eligible for settlement.
we will give an undertaking whenever government is required this land, we will have to surrender.
Now, your application have been rejected, whether anything has been provided or not.
Nothing has been provided. We have got no order.
No order.
But they wanted to give the land.
Let it be communicated.
Lordship.
We had not been received, my lord.
Now they,
But they wanted to this land to give it to other private person. When we have come before your lottery, now they have stopped it.
How can it be, it can be lordship? Yes, it is
And
a
he is
roadside
he
land.
is a pattal
have
land.
been rejected as applied for land falls within roadside reserve and hence not eligible for settlement.
But we have been running this market since long, that land.
Right, if the land is not,
Further extension of the area, because we cannot accommodate all the persons in the market.
now after preparing this petition, you are more in danger.
Yeah, really.
Now you are more in your danger.
Exactly.
Has increased now.
Now they have taken. the
Now it
idea
is categorically held at roadside reserve. Roadside reserve means it, like VGR, it cannot be
But that-
settled.
Till then, till their requirement, we may be allowed to continue.
No, only thing that the order is to be communicated to you. We are will not keeping this pending. Since they have made a statement,
Villagers will be the market will be uprooted. Where will go? my-
order is to be communicated to you
Ah.
as regards the rejection of your application. And till the order is communicated, the status quo as on date will be,
Status will be maintained and my lord, I-
status quo as on date will be maintained.
Kindly.
We can
Huh?
observe that much.
My lord, even there is a permanent construction on the other.
Law will take its own course. You challenge this. After the order is communicated, you have to challenge it. A fresh cause of action now,
Yes, true.
They have to challenge lordship.
is it not?
Right.
For that, till that order is communicated, status quo as on date will be.
A very unfortunate condition is the situation is that the adjacent land, who is a pattal land holder, he wanted to occupy the land. When we have objected, then whole things has come up. Respond number 6, he illegally occupied, given a paka wall upon the Sarkari land. That we have objected.
Oh, your Bazaar committee.
Yeah, Bazaar committee, yes. We have got no land, then where will go?
My house is standing.
Huh?
Respond number 6. His house is there.
Yeah,
Oh,
how-
you are also roadside.
Yes, he is the respond number 6. Roadside.
My partner.
He is having pattal land, he has occupied the vast, more than 3 acres of land he is occupying.
There is my house is there.
Your house is there, our market is there.
No.
He is not disturbed, but we are disturbed, madam.
That cannot be made. Just in front of my house. It's rude.
If he is permitted, my lord, to continue his dwelling houses on the Sarkari land, our market, they are uprooting.
What is your case? You are trying to
No,
evict him from his.
The land he has been occupied from Sarkari land may be given to us as additional land. Now we are in problem by asking for additional land.
Huh?
Now we have become problem. But we asked for additional land and to evict him. Now he is occupying, given Pakka wall, he has occupied the entire land.
Lordship, may kindly see the pair portion.
No, you are seeking allotment of government land measuring 3 katha 4 lesa,
Exactly.
covered by DAG number 268.
Yes.
Right?
Yes. He is also occupying that adjacent plot.
So your settlement application by both the parties
Yes.
means he also.
For settlement.
But both have been rejected.
But then where we will go, my lord, that is the problem.
That is, you are,
Public interest is to be considered, my lord.
public interest is also about the roadside land.
Very true, my lord.
See the situation in Guwahati.
The deputy commissioner should think of.
See the
alternative-
situation in Guwahati. How much time
I appreciate
it
your-
takes
Yes,
you
yes.
to reach your house after the court?
Yes. Then, my lord, alternative.
Roadside land?
So, yes, it cannot be occupied. Yes. Then, my lord,
Hard.
it may be given, my lord, alternative area. Deputy commissioner may be direction.
Find application. We are not here.
Not considering our application, my lord. That is the problem.
That is
No,
not.
your repetition is structured
Lordship.
for allotment of that particular land.
Lordship, kindly give that observation that,
No.
that,
Make
That-
an application thereafter come.
that objection I want that.
No, make an
You should-
application for allotment.
Your
Then
lordship,
if it
that
is not
allotment-
considered, come in a writ petition.
It is a
But
market
here
area.
your case is that for allotment of 3 kathas, 4
Yes, sir. To
lessers.
continue the market in an alternative
Mr.
place, my lord.
S.
That is not in the pair law.
In an alternative place, my lord.
Heard Mr. S.C. Vishwas, learned counsel for the petitioners.
ওর মানা করে উত্তর ক্যান্সার ওই দিশে লেখে দিতে হবে
Mr. J. and Mr. S. Doctor, learned standing counsellor, Revenue Department for the respondent number 1. Mr. J. Henry, learned Junior Government Advocate Assam for the respondent number 2, 3 and 4. Who is Panchayat? Mr. U. Sharma, learned counsel.
On behalf of S. Doctor.
Representing Mr. S. Dr. Learned Standing Council, Panchayat and Rural Development Department for the respondent number 5 and Mr. S. Islam, Learned Council for the respondent number 6. Full stop. The petitioner number 1, Nutun Kathmi Bazar Committee, owns and possesses a plot of land measuring 2 bighas, 1 katha, 5 lessers, covered by DAG number 269 at village Nothun Katmi, Mauza Suntoli, Pomoria Revenue Circle, District, Kamrup. And within bracket subject plot number 1. And it runs a daily stroke weekly market thereon in the name and style of Nutun Katmi Bazar. Full stop. The market named Nutun Katmi Bazar is situated by the side of Somoria to Kuntoli via Kolatoli Road. Full stop. On the north side of the market, Notun Katmi Bazar, there is a government plot of land, a plot of land belonging to the government measuring 3 kathas, 4 lessers, covered by DAG number 268 within bracket subject plot number 2 for short, which is adjacent to DAG number 269. Full stop. As the subject plot number 2 is contiguous and adjacent to subject plot number 1, the petitioner society had submitted application for allotment of the subject plot number 2 in its favor. Full stop. Any mention about respondent number 6?
Well, that is 269.
The petitioner committee finding that the respondent number 6 had also made application for allotment of the subject plot number 2.
That is 269.
269. Both are claiming 269. The petitioner has approached. Petitioners have approached
Deputy Commissioner
by this writ petition, seeking inter alia direction to the respondent authorities, more particularly, the respondent number Two.
Oh, two, yes.
To allot, to make allotment of the subject plot number 2 in favor of the respondent number, in favor of the petitioner number 1 committee, and not in favor of the respondent number 6, on the premise that the respondent number 6 has already owns sufficient land in his name. Full stop. Para. On when the writ petition was listed on 24/7/2023, the learned State Council was requested to obtain instructions as regards the status of the applications submitted by the petitioner number 1 committee and the respondent number 6 in respect of allotment of the subject plot number 2. Mr. Henrik, learned State Council, has furnished a communication bearing number so and so dated 10/8/2023, addressed to him by the additional Deputy Commissioner Kamrup Amingao. Full stop. A compliance report is found annexed to the communication dated 10/8/2023. Full stop. As per the compliance report submitted by the Circle Officer, Somoria Revenue Circle, the applications made by the petition number 1 committee and the respondent number 6 in respect of for allotment of DAG number
269, 369.
268 or
268.
allotment
269.
for subject plot number 2 have been rejected as the subject plot number 2 falls within roadside reserve land and is not eligible for settlement. Full stop. Both the learned, in view of rejection of the applications for rejections of the applications of both the petition number 1 society and the respondent number 6, the present writ petition is rendered infructuous. Full stop. Both Mr. Biswas, learned counsel for the petitioners, and Mr. Islam, learned counsel for the respondent number 6, have submitted that the order rejecting the applications for allotment submitted by them have not orders have not yet been communicated to them. Full stop. They have submitted that if the order rejecting their applications are furnished to them, are communicated to them, they would be at liberty to avail appropriate remedy under the law, challenging such orders of rejection. Mr. Henrik, Learned State Council, has submitted that the orders within bracket as per orders rejecting the applications for allotment of the subject plot number 2
68.
of the petition number 1 society and the respondent number 6 would be duly communicated to them,
If already, if my lord is
if not
communicated.
already communicated. Full stop. Who is occupying?
That portion is occupying by respondent 6.
Hmm?
Other portion we are running market. 268 we are running market. I think there is no embargo for 268 now, that number.
No.
Yes.
268 is embargo.
269 is embargo now. They cannot allow. They cannot allow 269.
Huh?
So 269
There is
will
nothing about you're already, your land is 260.
268 where market is going on.
No.
My land. It means that my house is there.
269 is running. Where we want.
No, your land is 269.
Yes, 269.
There are two.
Yes.
That there is no,
There's no.
There's the market.
there is nothing. You are running a market.
Yes.
You try to
Extend.
extend
Which has been
by
occupied.
getting allotment of 269.
Yes.
Okay.
There is a stay order out from the High Court.
So stop.
That's not true.
With the observation that the orders rejecting the applications of the petition or rejecting the application for allotment, applications for allotment of subject plot number 2
260 disturb করে নাই।
by the petition number 1 society and the respondent number 6 shall be communicated to them,
It has not been-
comma, if not already communicated within a period of 30 days from today, the writ petition is closed.
With an interim order, that may be. That may be.
What interim order? What interim order?
Interim order is not to construct boundary wall in the land.
My house is there. Because of that order, my lord, I cannot open my gate, my lord.
Huh?
Because of that order, my lord, I can.
Which order?
Para 5 of this last order. Last order, para 5.
Construction is not there. It is my house road, my.
Lordship, my lord, kindly see the order.
260.
Last line to look. Moreover.
He wanted, so that he may not construct matter.
As a subject plot number 2 is a roadside reserve land as per revenue records, there shall not be any construction
By the respondent 6.
by any of the parties.
Yes.
Any of the parties, save and except the state.
Obliged.
My gate will be.
I accept.
Yes, because by that side pillar, my gate is there. The house.
Shall I make further observation?
That may be.
In view of the order passed today, in the writ petition, the interlocutory application is accordingly closed.
Item number 45.
Captain.
May I please your lordship? Lordship may kindly pass over the matter for a week.
No Passover.
It gets
Nobody has
processed.
filed anything. Yes,
Lordship, I have received instruction.
to file it.
Send it for vetting.
MS,
Autolikits.
your name please
Autolikits. I'll write down.
for the petitioner. MS B Sharma, and Central Government Council.
In 45 lordship, the affidavit is ready. We're going.
Central Government Council for the respondent number 1,
Yes, Lord.
Mr. J. Hendrik, learned Senior Government Bukit Assam for the respondent number 2, 3, 5, 6, 7, 8, and MS N Border, learned Standing Council Revenue Department for the respondent number
4.
4. Full stop. MS Formal learned CGC and Mr. Hendrik learned State Council have submitted that they have received instructions and the contract which will be filed within 4 weeks' time. they have thus paid for listing of the case after 4 weeks to allow them to file the counter affidavits. The prayers allowed list the case after 4 weeks on a date fixed by the office.
46 to 48.
Morning, somebody made a mention, right?
Yes, Michael.
But consent was not taken.
Yes.
So that is not the practice, so I have made him wait. This is not the way to make mention.
Otherwise, your lordship, the eviction matter, your lordship, without initiation of any eviction process, the.
You are already enjoying status quo.
Lordship, today morning only we have received parawise comments.
Okay.
Let them file affidavit.
So what will be?
Lordship, in fact, Lordship.
What will be your submission?
Lordship, to file affidavit, Lordship.
One, by what time?
2 weeks.
2 weeks. Heard Mr. R. Mojumdar, you are representing in all the writ petitions.
In 47.
This is railway license, expiry,
Expired.
license agreement.
License agreement.
R. Mojumdar, learned counsel for the petitioner in,
47, my name is there, and in 46, 48, my junior.
and
colleague-
Mr. H. A. Talukdar, learned counsel for the petitioners in 46 and 48. Also heard M.S. B. Sharma, learned Central Government Council for the respondent number 1, 2, 3,
All lot.
4, for all the respondents. M.S. Sharma, learned CGC has submitted that instructions have been received to file the counter affidavit, and the counter affidavit will be filed within 2 weeks' time. M.S. Sharma has thus sought for listing of the case after 2 weeks. The prior is allowed list the case after 2 weeks for filing of affidavit by the counter affidavit by the respondents. The interim order passed earlier shall continue till the next date.
Lordship, 3 writ petition or 3 different central government councils.
Okay.
I mean.
B. Sharma, learned Central Government Council for the respondents in
48, item 48.
48.
I am
And
46.
Mr. K. Gogoi, learned Central Government Council
46, Lordship.
for all the respondents in
46.
46. MS R. Devi, learned Standard Government Council for the respondent number for all the respondents in 48.
Lordship, in respect of 46, Lordship, I have yet to receive instruction.
Okay, তাৰপিছত লিখিব বি শৰ্মাটোৱে লিখিব আৰু মিষ্টাৰ গগৈ learned CGC and MS R. Devi learned CGC have paid for further 2 weeks time to obtain instructions.
We have received, Lordship. Yes, receive only I have to receive. Lordship.
Okay, তেনেহ'লে লিখিব এই শৰ্মা আৰু দেৱী similar লিখিব Mr. Gogoi লিখিব Mr. Gogoi learned CGC has sought for further 2 weeks time to obtain instructions. Place the cases after 2 weeks. The interim order passed will continue till the next date.
For orders, item number 49 and 50.
I'm appearing for both the contemnants today. Today is my first appearance. Lordship. I'm appearing for the first time.
First time.
Lordship.
Okay.
And Lordship, the contempt number 2. He has been already been transferred from that post. Lordship. He is no longer holding that post. Lordship. New incumbent has joined. Lordship.
But when is the interim order or order? What is the order? Contempt number 2.
The notice was issued on both the respondents.
Contemptor number 2.
Devasis.
What is the violation?
This honorable court
2/11/2022.
direction was to take the personal hearings of both the petitioner and the private respondents. And we have submitted our written submission before the Biswanath Municipal Board. But they have not, the private respondent has not approached, or our application or representation was not.
Who was to hear the application?
The contempt number 1 and 2 both.
1 and 2.
Yes.
Then file your response. Transfer is different matter. When you were transferred?
Lordship, but it's more than a month now.
But that order is of 2/11/2022. You file your response.
Lordship. But
that will not.
I understand, Lordship.
Extricate you.
No, Lordship, I have some Part of the instruction I have already received.
Okay, bring that thing that you have been transferred
But he
in the
cannot,
counter affidavit.
Lordship, the respondent number 2 cannot.
It is up to them to include the new one.
Yes, ma'am.
Respondent number 2 cannot file his power in the earlier capacity, Lordship. That is the only difficulty.
Here it is by name, not in earlier capacity.
Lordship.
In contempt, it is not in the individual capacity.
Lordship. I'll file power.
Your name, Mr.
DM Nath.
Heard Mr. D.M. Nath, learned counsel for the petitioner. In contempt case number so and so and for the petitioner in WBC number so and so. Mr. Didas, learned counsel, has submitted that he is entering appearance for the respondent number, both the respondents in contempt case number so and so, and has sought for
4 weeks. 4 weeks time.
4 weeks time to file counter affidavits on behalf of affidavit in opposition on behalf of the respondent number 1 and the respondent number 2. Full stop. He has further submitted that the respondent number 2 has been transferred from the post of executive officer Vishwanath Sariali Municipal Board in the meantime. Full stop. The prayers made by Mr. Das in contempt case number so and so is allowed. What about the repetition?
My lord, notice has not been issued yet. Notice has not been issued yet, my lord.
Notice has not been issued yet.
Yes, my lord. The earlier occasion court has expressed the mind that let the contempt process.
This contempt petition is arising out of another petition or what?
Yes, my lord. Yes, my lord. WPC number 2354 of 2021.
How this is
Subsequently, we have filed
added? How this is added?
Subsequently, the writ petition.
How the two writ petitions are?
One, they are correlated.
By which order?
My lord, by order dated 2/11/2022, my lord, the earlier petition.
The order was passed in WBC 2354/2021.
My lord. Subsequently,
is there any order taking both the matters?
No, my.
Then how? Who has added?
My lord, we have subsequently the writ petition was tagged with the contempt.
Where is the order?
No order was as such passed, my lord.
How can it be then? There is no order.
No.
It is to be detached. Mr. Nath.
My lord.
This petition is to be detached, delinked. There is no order either in the contempt case or in the petition to tag both the matters. On the prayer of Mr. D.M. Nath, learned counsel for the petitioner in WBC number so and so, the writ petition is delinked and the writ petition be listed in the motion column after 2 weeks.
Lordship, in writ petition, Lordship, I can appear for respondent 2 and my name is not shown and copy is not served also. Lordship.
We are not issuing notice.
No,
It will be listed in motion column.
Lordship, the copy.
Then only will.
No, Lordship, I am the standing counsel of Vishwanath Sariali Municipal Board.
Okay. Mr. Nath, then you serve.
I'll serve.
You serve the copy in the
By
meantime.
tomorrow itself.
Mr. Nath, learned counsel for the petitioner has submitted that he will serve copies of the writ petition to Mr. D. Das, learned standing counsel, Vishwanath Sariali Municipal Board, within 3 days from today.
And also a copy of the contempt petition. Lordship. A copy of the contempt petition.
Okay.
Item number 51. 51.
Heard Mr.
A. Mubarak.
A. Mubarak, learned counsel for the petition. The instant condemnation has been filed, alleging disobedience of the direction made in an order dated 19/10/2022, passed in a writ petition WPC number 6664/2022. Issue notice returnable in 4 weeks. the petitioner should take steps for service of notice upon the respondents by registered post with AD within 2 working days from today.
52,
AFNU Mullah for the petitioner. Agoto Nishan, order dated 7/11/2022, passed in writ petition WBC number 7053/2021, issue notice returnable in so and so. Petitioner shall take steps within 2 working days from today.
Obliged.
53,
May I please, Your Lordship? Lordship, here the petitioner has pronounced Talaki Hassan upon the respondent number 4, that is my.
Why it has come for orders?
My lord, there's a private respondent, number 4. Whether the step has been taken upon the respondent number 4 or not, my lord. And even the lordship bar respondent.
Have you read 19/10/2023 order of the Lower Jimma Court? Huh?
No, lordship.
Hi, Mr.
R. Islam.
R. Islam, Learned Counsel for the petitioner. MS N. Bodoloi.
1.
Learned Counsel for the respondent number.
1.
Learned Standing Counsel Revenue for the respondent number 1. J. Hendrik Learned Government Advocate Assam for the respondent number 2 and 3.
3, lordship, I cannot appear, my lord, on behalf of 3. My lord, it should
Okay,
be,
for the respondent number 2.
and my lord, it should be by name, my lord, party, as because.
Oh, I have not done.
Register, my lord, Kaji and my lord. MMR and Kaji, my lord, it should be the by name part.
Mr. Hendrik has submitted that he notice in respect of the respondent number 2 was inadvertently accepted.
Respondent number 3, lord.
Respondent number 3 was inadvertently accepted on 14/8/2023. By order dated 19/10/2023 of the Lower Jimma Court, the petitioner was directed to take fresh steps for service of notice upon the respondent number 4 in the mode mentioned therein within 7 days. So stop. Mr. Islam, Learned Counsel for the petitioner, has submitted that he may be granted further 3 days time to take steps for service of notice upon the respondent number 4 in compliance of the order dated 19/10/2023 of the Lower Jimma Court. Full stop. The prayer is allowed. The petitioner shall also take steps for service of notice upon the respondent number 3 by registered post with AD within 3 working days from today. This is the case after 4 years.
May I pray for date, lordship? May I pray for date?